and 6. Item number 4, 5, and 6, my lord. We have filed an affidavit in reply yesterday, my lord. It may kindly be called for record. My lord. You have another prayer, my lord. I'm praying for listening of this matter tomorrow for withdrawal, my lord. This matter for listening tomorrow for withdrawal, my lord.
What?
Withdrawal. Develop.
May I please, Lord? Lordship, I beg to mention item number 3. I am appearing on behalf of Mr. P. Sharma, standing counsel, Lordship. Lordship, he is unwell.
What?
Item number 3. I am appearing on behalf of Mr. P. Sharma, standing counsel of FDC, Lordship. Lordship, he is in Delhi. He is admitted in hospital, Lordship. So kindly adjourn the matter for 4 weeks, Lordship.
Why the matter come up?
Lordship.
Why the matter come up today? Have you taken the consent of the other side?
Yes, Lordship, yes. Consent has been taken.
Taken the consent
Yes.
of the other side,
Yes, Lord.
and they have no problem.
No, Lord. They have given consent, Lord. They have given consent.
Is there interim order?
No, I don't have any idea, Lordship, regarding this.
Don't mention that. We'll see when the matter is.
But there's no any interim order.
You have no problem.
Well, here's some problem.
The request of the learned counsel for the APC matters can be adjourned to be lifted up for 4 weeks.
May I pray for a date, my lord?
No date.
May it please, Lord, I'm praying for listening of a motion matter tomorrow, my lord.
Why?
My lord, my bid has been rejected. My tender was submitted, my lord. My tender has been, technical bid has been rejected, my lord. I'm challenging it tomorrow, my lord. Much obliged.
May it please, your lordship. First, I beg to mention for 2 admission matters, my lord. May I pray next for admission matter?
Mission pertaining to
Pertaining to bill, contract bill, my lord.
Huh?
Non-payment of contract bill.
10th of November.
I am difficult.
May I please, your lordship? Lordship, with regard to item number 12, my lord, I beg to withdraw, my lord, on instruction.
You are
A Gayan.
the guy and the learned counsel appearing on behalf of the petitioner submit that the instructions to withdraw the petition. Accordingly, the petition stands closed on withdrawal. In time order, you can stand taking.
Much obliged, my lord.
For hearing item 9, fixed at 10:30 a.m.
Yes, what has happened?
My lord, to release whether that land is required or not, my lord, for that we have wrote a letter to the circle officer to determine the exact position of the land, my lord.
No, there is no more further demarcation.
The demarcation is not
Don't
because
delay further.
no, my lord, demarcation not for the demarcation, my lord, to
They
release
have
that.
already demarcated and found out which is the land.
Yes, but that is comprised of not only DAG number 5, my lord, as per the whatever the land in our position, my lord, that is not only DAG number 5, that other DAG is also there. So to release that DAG number 5, we have to know that the actual place of that land, my lord. So we have wrote a letter to the circle officer, and circle officer called us on 7th of 11 to 7/11/2025, my lord. Not only me, also the petitioner, my lord.
Let September 24, the order will also will kindly see same order was there. Now also they are
No.
saying, because the report says that the land which they are in possession.
No, what
Yes,
is
my
the
lord.
intention behind that?
My lord, we have to
Plus, we are in
Is there
same position
intention
from
behind
September
That will-
24.
My lord, whether we are going to release or we are going to give the acquired the land, my lord, that will depend upon the exact position of that is because whether that is backside or in front of our side, my lord, or whether there is any construction or
Was the
not.
demarcation not done in your
No,
presence?
demarcation is not, my lord. If the circle officer says this is the DAG number 5, then we are going to work on that, my lord, for release or for acquiring or for anything, my lord. So that is only the position, my lord.
That
That
is already there, my lord.
What is going on? Because I asked the circle officer and the circle officer on the basis thereof has made the assessment and given a report. What else is required?
So-
Only because of that, I better about it. Another to 5 better that.
petitioner.
This are also filed that some report of the.
2013, my lord, the circle officer and the deputy commissioner, they've given a report, my lord, that the land which is in possession of the CRPF officials. What more they want now?
My lord, we don't want anything. I think we have to release what portion of the land, my lord. That is the main question, my lord. That's
I'm
why.
not aware upon demarcation, because the demarcation means, what is this? It is demarcated which land it is the death of the petitioner.
Yes.
Isn't that known?
No, my lord, demarcation was done on the earlier occasion also, but they said that that is inside the land of the CRPF, my lord. That is under the position of CRPF,
The
my lord.
demarcation is done physically.
Physically, that
It
they
is
did
not
not.
done in the maps in the office.
No, they did not.
It was done in your presence.
In our presence also,
Then-
my lord, but they did not identify the actual area of the rest. Dag
What is
number
this
5.
area of the land of the
Dag
dag
number
number
5.
five and not?
There are 2 dag in that inside that Himbala land.
You
my lord, as
don't
per
have-
the also.
You don't have a right in respect to the entire land.
Yes.
In fact, we should issue a notice to all persons who are the claimants in respect to the land and give the entire land back to them, the entire land. You should not be there at all.
And
There's
my
no
lord,
business out there to be there. You are a government, you're a government entity. How can you take over somebody's land?
no, even my lord,
It
petitioner
is
also.
apparent from all materials
Yes, ma'am.
that you are in occupation of petitioner's land and you don't have a allotment.
Yes, my lord, we are in possession
So
of the
you need to
petition.
vacate.
We are in the
I think we
possession.
should
What-
ask the government to make it vacate the entire thing. Why the government is not taking action, Mr. Henry? The entire land. Forget about his land. Entire land. The entire land should be vacated. They have no business out there. What is your right to be remain over there?
But-
You don't have an allotment.
No, we have allotment in.
Where
some
is your
portion.
allotment?
Some
So,
portion
no,
of the
show me
land,
where is your allotment. You don't have an allotment. You say that I have lost the allotment. There's no records out there for allotment. Then what do you mean? Are you trying to play with the court?
So, my lord,
It
since-
appears so.
no, my lord.
No, the
since my
question
lord-
appears that you are trying to play with the court.
No, my lord.
Yes, because of
Yeah,
the
the-
fact that
the-
the demarcation has already been done in your presence.
No.
What do you mean by
My
demarcation
lord,
then?
demarcation is that.
Means now in the office he will tell you.
No, my lord, demarcation in that in respect of dag number 5, my lord, that is that is fact that is the land of the petitioner, my lord, and we are in possession of the that land. So, my lord, court has directed to in respect of dag number 5, my lord. So we are also ready to, as per the court order, my lord, comply the court order, my lord. But as what portion will release, my lord, and what portion will acquire, my lord, that is the main issue here, my lord. So that's why they
Page
also
30
wrote.
of the writ
my lord,
petition, my lord.
petitioner also
Dr.
wrote a
Will kindly
letter
turn
to
to
the
page
circle
30 of the
officer.
writ petition.
Kindly
Circle
see, my lord.
officer's report
They also
way back in
request the circle
2012.
officer also. Petitioner also requested the circle officer, my lord, for that.
Page 30, my lord, way back in 2000.
And when did you approach the circle of
They approached on, my lord, 26/8, 2025.
23
26/8.
after this order? Why have you approached the circle
My
officer?
lord, I am not aware. Sir.
Wait.
When the thing is going on your line in the court, why you have?
My lord, I am not at all aware of this. Just now I came to know about this, my lord.
What you are saying, put it on affidavit. We'll have it on next Monday.
Next month, my lord,
Next Monday, put it on affidavit. What you are saying,
yes.
that you are aware that you are
On
in,
writing, my lord.
no, on writing that you are aware that you are in possession of the government, the petitioner's land. You want to ascertain from the circle officer that how much of the land you want to keep and how much of the land you want for
Yes, sir.
what you are making that submission. Put it on affidavit. You'll have it on
Affidavit.
affidavit.
Yes, my lord.
Put it on affidavit. We'll have
Yes,
it on
yes,
next
ma'am.
Monday. Tuesday. Tuesday.
Well,
We'll have it.
I'll-
Then I will grant.
Yes, my lord.
It has
My lord,
been
Monday,
submitted.
my lord, on-
Wait. Miss A. Gayan, the learned counsel appearing on behalf of the respondent. Number
number 2, my lord.
submits that the petition, that the respondent number 2 is now pursuant to the demarcation proceedings aware of the fact that the respondent number 2 is in occupation, is in occupation of the land belonging to the petitioner. However, on account of ascertaining how much land the respondent number 2 would like to keep and how much land the respondent number 2 would like to acquire, they have contacted with the circle officer, concerned circle officer, and the circle officer has given time on 7/11/2025. Take this, it is the opinion of this court that the said submission be brought on record by way of an affidavit so that further directions can be passed in the instant proceedings. To list this matter on 28/10/2025 at 10:30 AM. The affidavit be filed by 27th of
Yes, ma'am.
October 2025,
Must oblige.
along with relevant documents.
Lord, I'll
Immediately item
inquire
13.
why this has come, my lord. I'll inquire, my lord. It was not necessary. It is 26 it. Okay,
You are causing problem to yourself.
that is why, my lord.
Must oblige.
Oblige.
Supplementary item 13 for motion.
Wait, please, Your Lordship.
Yes, what is it?
Madam, challenging the settlement order,
Visually,
settlement order at page 15 by the missing autonomous council. Although my lord had held in a batch of writ petitions, we have annexed the order that the missing autonomous council does not have the jurisdiction at present.
now what is the missing autonomous?
The missing autonomous council has went on to settle
Again?
officially. That's what. Of course, it's a covered case. It might be a suo motu contempt also, but we are not on that.
Sumo to contempt is for contempt. I am not going to initiate contempt.
But now, so far as this is concerned, our agony is we had participated in the tender process for the Sesanodi fishery, and that
I think the missing autonomous council thinks that
I've annexed the order of my lordship in the
where, what are you challenging here?
page 15,
Page
15,
5.
1-5. Number 1. May I read, my lord?
Sesanoti,
My lordship.
this is by missing autonomous council.
And my lord's order starts at
11:9. We set aside this.
absolutely.
You want only the setting aside of.
Yes, 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 nothing more.
Heard is the exponent, the learned counsel appearing on behalf of Krishna. Mr. What's your name? D. Gogoi appears on behalf of the respondent number B 4. 3 and 4. Ms. So-and-so appears on behalf of respondent number 1 and 2 and 6. Mr. MCT appears on behalf of the respondent number 5. The petitioner herein, who are you?
I am a fishery cooperative society.
Understood?
Absolutely.
This
my
is a
lord.
public interest litigation.
No, 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 no. We have participated in the tender process Annexure C for Sesanodi fishery. And now we are the highest bidder. In all likelihood, it will be settled with us. We see that now missing has autonomous council has settled a part of the fishery, which is not in
Where
consonance with
where is your statement?
my lordships. That statement, lordship comes to page 9, towards the last part of the paragraph 8. It is stated that a notice, if I may read that part, from the, I have stated that
Wait,
at page 9. Towards the middle, it is stated. It is stated that a tender notice bearing number so-and-so dated 22/8/25 was issued by the Additional Deputy Commissioner Fishery Dibrugarh, inviting tenders for settlement of, amongst others, Sesanodi Part 1 fishery, a 60% category fishery, and the petitioner society has participated in the said tender process, so initiated for settlement of Sesanodi Part 1 fishery.
but you have made the respondent number 7. Would it be proper to dismiss, allow the repetition without hearing?
That's one view, exercise that in law, but he has a right to respond. May not be state. I mean, I'm praying for a state then.
But if I'm staying it, does it make any sense?
Express bad in law,
What is expressly wrong?
bad in law. It's express bad in law. I'm on that.
The instant restitution is taken up for disposal at the motion stage, taking into account that the actions on the part of the respondent authority are completely contrary to the law laid down by this court in the case of Dibrugarh Fishery Cooperative Society Limited versus the state of Assam. Is it reported?
I have to check it. Should have been reported.
I think this is reported.
It is reported. My-
The case of taking into account that the in view of the law well settled by the court in the case of Dibrugarh Fishery Cooperative Society Limited versus state of Assam. By the judgment that order dated
20th of August, 2024, page 41,
28,
2008.
28, 2024, in the case of Dibrugarh Fishery Cooperative Society versus state of Assam and other record deputation number 3065 of the 2024. The petitioner herein have attained the petitioner herein, which is the registered cooperative society, fishery cooperative society, had participated in a tender process
My lord,
initiated by the additional deputy commissioner of fishery Dibrugarh
my lord.
dated 22/8/2025 for settlement of various fishery, including Sesa Nodi Part 1 fishery. It is the case of the petitioner in Sesa Nodi Meen Mohol, which is sought to be settled by way of tender by the missing autonomous council by inviting a notice inviting tender dated 11/9/2025 is a part of the Sesa Nodi Part 1 fishery. The grievance of the petitioner herein is that the missing autonomous council, in view of the law laid down by this court in the case of Dibrugarh Fishery Cooperative Society Limited Supra, would not have invited any tender for settlement of fishery, as well as settle the fishery in favor of the respondent number 7. This court inquired with Mr. D. Gogoi, the learned counsel who represents the respondent number 3, 4, 3 and 4, as to how the missing autonomous council have initiated the process of settlement of the fishery, being Sesa Nodi Meen Mohol, bracket Sesa Kinar Moina missing down to Sesa Muk Rongdora down, bracket by the notice inviting tender dated 11/9/2025,
No, it's a
as
settlement
well
order.
as the subsequent order of the Min Mahal dated, as well as
11-9 is a settlement order. No notice. tender.
by the
Directly-
settlement order as to how the, right, the settlement order settled by a settlement order dated 11/9/2030 in respect to sexual litigation. The learned counsel submitted that the issue is duly covered by the judgment of this court in the case of Dibrugarh so and so Cooperative Fishery Cooperative Society Limited Supra, wherein this court have categorically held that the missing autonomous council has no authority or jurisdiction to settle any fishery. This court further have duly taken note of the judgment of this court in the case of Dibrugarh Min Mahal Society, Dibrugarh Fishery Cooperative Society.
Page 63, last part. Under such.
As well as the observations made by this court in the said judgment at paragraph number 48, 49, and 50, which being relevant are reproduced hereinunder. This court further inquired with Mr. D. Gogoi, the learned counsel appearing on behalf of the missing autonomous council, as to whether in any appeal there against the judgment and order against the judgment and order passed in Dibrugarh so and so have been filed. The learned counsel appearing on behalf of the respondent number 3 and 4 submitted that no appeal against, there is no appeal filed by the missing autonomous council. In other words, the missing autonomous council have duly accepted the judgment passed by this court in the case of so and so Dibrugarh Fishery. Considering the above, it is therefore the opinion of this court that the settlement order made by the respondent number 3 and 4 in favor of the respondent number 7 is without jurisdiction and authority. Settlement order dated 11/9/2000 is without jurisdiction and authority. And accordingly, this court therefore sets aside the settlement order dated 11/9/2025 issued by the respondent number.
3 and 4.
There is one person who signs it.
Principal Secretary, Miller, that's 4.
Four. Huh?
4.
Four. Issued by the respondent number 4 in favor of the respondent number 7. So accordingly, the petition stands allowed.
Grateful, obliged.
What are the line at the legal paragraph? Before it is the line at the upper. This court is taken up for motion for disposal. Taking into account that the map issue involved in the instant requisition is well settled. It is therefore the opinion of this court that the notice upon the respondent number 7 can be dispensed.
Obliged, Lordship.
For admission, item 1.
May please, your lordship. Lordship, compassionate appointment. The petitioner number 1 is the wife of the deceased, lordship. He was an employee supervisor in the family court, lordship. Kachar Silchar. respondent filed affidavit in this case saying that as per 2017, our case will be considered, Lordship.
Who are you?
And the widow, petitioner number 1 is the widow of the deceased and petitioner number 2 is the son of the deceased, Lordship. First within 1 month, petitioner number 1 applied,
And when did the person die?
Lordship 2016. 16,
Person died in the year 2016.
yes, Lordship. 29/7/2016 he died and 29/8/2016 we have applied, Lordship. And when she passed higher secondary, she again applied in the year 2017, Lordship. And after attaining majority, petitioner number 2, she applied for appointment of her son, Lordship. That was forwarded in the year 2017 and 2018, saying that our appointment will be considered as per notification 2017, Lordship.
But 2017 notification is not there. It has already been done away with.
But Lordship, as per
2017 notification, मतलब if you died in 2016, 2016 man. So at that point of time, scheme was there. That is true. But here is mother's claim, son's claim, both are claim, but they which they have claim, but they are already SS, that is double SLC pass. So they are not eligible.
They are
They are not eligible.
for peon.
Peon.
Why? They are
Because you are not-
overqualified.
Page 41, you will see appendice.
son is
They are
studying.
overqualified.
Lordship, in this course, I may not be considered, but Lordship, in compassionate appointment, my case may be considered.
No, but the fact remains that
10 years, madam.
10 years is okay. Another 10 years to 10 years only. But the fact remains that
Lordship, I have gone through the
2017 notification has been withdrawn.
Yes, Lordship, on 19
If the
April
notification is
2018.
Withdrawn. it was
19 April
given, and then it
2018.
was withdrawn because your right accrue in 2016 when there was no notification.
Lordship, 2016 will be considered as per 2017
Understood.
notification.
But in 2017, the notification came.
Lordship,
And then in 2018, that was done away with,
yes,
Yes.
Lordship,
that notification.
Lordship.
Now the question is, this court has to direct them to consider on the basis of a notification which was in existence, which is no longer there.
But Lordship, Supreme Court in Ashish Awasthi case says, Lordship, the case will be considered at the time of death of the disease, Lordship.
So at
Compassionate
that point of time, there was no notification. Where is
Lordship.
the notification at that point of time?
At that point of time, there was no notification,
No.
but my case, before
So
maybe
you accrue
2015
the right
notification,
subsequently.
Lordship, before that 2015 notification was there.
Where is the-
It is not mentioned in the petition, Lordship, and they have in affidavit in opposition stated that my case will be considered as per 2017 notification, Lordship.
Huh?
17 notification, affidavit in opposition, paragraph 4, Lordship.
Now, how are you surviving?
Lordship, family pension, comprehensive family pension.
Oh, then.
Lordship, that is another right,
How are
and
you
this is
getting comprehensive family
three
pension?
minor
You're
children,
getting the entire salary.
Lordship.
Then
Then my lord,
That
Only
means
that
you are
will-
getting the benefit under the 2018.
No, Lordship, that is another aspect. Lordship.
No.
Pension is
No,
another.
no, if you are getting, then you cannot get that.
in lieu of that,
That is in lieu of
Lieu.
that.
But Lordship, it was, he died in the year
Then you
2016.
give up, you return all the money which you have received.
Yes, Lordship, if my appointment.
Then we will
they-
consider,
that is.
you return it.
If they consider my appointment, Lordship, then I am ready to return, Lordship.
You cannot get all these things. And then we will consider whether you will get in view of that Debabrata Mulik judge.
Devabrata, Lordship.
You got it.
We will then consider, first you return the money.
Lordship,
25 finals.
Without an assurance, you return the money first, and then without an assurance, we will then consider in the light of that judgment as to whether we should give you.
Lordship,
Yeah,
first,
otherwise
first
you will-
Lordship, assurance for my appointment, then only I will return, Lordship.
Huh?
First assurance for the appointment,
No,
Lordship, then only I will.
no assurance, there is no promissory stop.
No, you cannot avail both.
No, you are getting, you return the money, all the money from 2016 onwards. Don't take any money. You cannot get that.
Lordship, that is compassionate appointment and this is pension, Lordship.
No,
That
Last line.
2017 is in lieu of family pension.
family pension is different. You are not getting the family pension. You are getting as per the benefits which have been on the basis of that the last drawn wages you are being paid.
Lordship, that is in spite of earlier Lordship, family pension was given to the employee, Lordship. Now.
Family
2000
pension is a different. Family pension is a computed on the basis of the amount of years he has worked, and on the basis of that he is getting it. That is not what you are getting.
Earlier, Lordship, family pension is given on the basis of basic pay, Lordship. Nowadays, after 2017, entire salary amount
Yes,
has
yes.
been given to the.
In
This
lieu of
is
compensation.
in lieu of that 2000 earlier.
That is last line of the letter.
Maybe I am wrong, Lordship, but that is in lieu
This is
of.
for compassionate family pension. How can you get for that?
This is compassionate family pension and that is compassionate appointment, Lordship.
No, we dismiss it.
But 2007.
Short order, no? We would not
Lordship, even if
even
it was
venture to
Lordship,
write a longer order. Taking into account that you have already taken the benefit of the subsequent scheme, how can you ask for the previous scheme? देखो, heard Miss R. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. T.J. Mohanto, the learned senior counsel, appears on behalf of the Guwahati High Court. Full stop. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not considering the case of the petitioner for appointment on compassionate ground, for appointment on compassion, for consideration of the petitioner for appointment on compassionate ground upon the demise of the husband of the petitioner number 1 and the father of the petitioner number 2. The case of the petitioners herein is that the petitioner number 1 is the wife and the petitioner number 2 is the son of one Arif Uddin Loskar, brackets since deceased, who was working as a superintendent of the learned superintendent in the office of the learned office of the Principal Judge Family Court, Pachar, Silchar. Late Arifuddin Loskar expired on 29/7/2016, leaving behind the petitioner and 3 minor children, including the petitioner number 2. The petitioner number 1, upon the demise of her husband, applied for appointment on compassionate ground, but the respondent authorities did not respond. The petitioner number 2, upon attaining the age of majority, also applied, and such application have also not been considered. It is under such circumstances the petitioner has approached this court by filing the present petition. The record reveals that this court, by an order dated 23/2023, issued notice. Pursuant to issuance of the notice, the respondent number 3 had filed an affidavit in opposition, wherein it has been mentioned that the case of the petitioner would be covered in terms with the notification dated 3/1/2017 issued by the Guwahati High Court on the administrative side. This court, while hearing the instant writ petition, inquired with Mr. T.J. Mohanto, the learned senior counsel, standing counsel of the Guwahati High Court, as to whether the notification dated 3/1/2017 is presently in force. During the course of the hearing, a notification dated 19/4/2018 issued by the Guwahati High Court on the administrative side have been placed, whereby it has been mentioned that the notification dated 3/1/2017 have been recalled. It is no longer in force in view of the scheme of the government as per notification dated 14/9/2017 and the office memorandum dated 31/10/2017, whereby the government of Assam, instead of granting compassionate appointment on compassionate grounds, have taken the policy to provide compassionate appointment, to provide compassionate family pension. The said notification is kept on record and marked with the letter X. This court, taking into account that almost a decade have passed since the death of the husband of the petitioner number 1 and the father of the petitioner number 2, inquired with Ms. R. Chaudhary, the learned counsel appearing on behalf of the petitioner, as to how they are managing the affairs, taking into account that they have been able to survive since they are able to as to how they are managing for the last 1 decade. The learned counsel submitted that the petitioners herein are receiving the compassionate family pension. It is therefore the opinion compassionate family pension in terms with the government notification dated 14/9/2017 and the office memorandum dated 31/10/2017. Taking into account that the petitioners have already taken the benefit in terms with the notification dated 14/9/2017, as well as the office memorandum dated 31/10/2017, it is the opinion of this court that the petitioner cannot claim appointment on the basis of the notification issued by the government by the Guwahati High Court dated 3/1/2017. Additionally, it is, where's the judgment, Devabrata? Additionally, this court also finds it pertinent to observe that the compassionate appointment on compassionate grounds is not a source for recruitment. Not a source for recruitment. Rather, it is a departure from the well-settled principles of, rather it is a departure from the general provisions providing for appointment to a post following a particular procedure of recruitment. Full stop. It is also pertinent to mention that the compassionate appointment is not a vested right which can be exercised at any time in the future. The Supreme Court in the case of State of West Bengal versus Debabrata Tiwari reported in 2025 5 SCC 712 have laid down the parameters as to when, and the parameters have laid down the principles on the basis of which the appointment can, on compassionate grounds, can be given. Paragraph number 32 and 33 being relevant is reproduced herein under. Full stop. In the instant case, well, taking into account the law laid down herein above and the facts involved in the instant case, it is the opinion of this court that the petitioner herein is not only entitled, is not entitled to claim appointment on compassionate grounds for the reason that the petitioner have already taken the benefit in terms with the notification dated 14/9/2017, and further the petitioner is also and further the petitioner do not fall within the ambit of the principles laid down by the Supreme Court in the case of Debabrata Tiwari Supra to be considered for appointment on compassionate grounds. Considering the above, the instant writ petition therefore stands dismissed. However, in the peculiar facts of the case, this court is not inclined to impose costs.
Obliged.
Item 2.
May please allow. Mr. Will kindly see the last order, my lord.
Oh, this one.
Yes. No parameter was laid down regarding my lord qualification criteria. Even the matter having been heard at length, the question arises as to whether the parameter set for fixing the minimum benchmark pertaining to qualification could have been the subjective satisfaction of the interviewer, taking into account that the selection board prior to holding the selection did not formulate any parameter as to how the educational qualification is to be assessed. It is also seen from the records that a non-fixing of the
The moment you are assessing educational qualification, you are touching on the merit and you are also touching on the rules. The rules do not permit. How do you incorporate or have a different qualification for a particular qualification, you give more marks? I set aside this thing.
But I'll just try to give a different picture. My lord will kindly have this Rajendra Kumar Srivastava. My understanding, I'll just place below, then lordship will take a call. Take on.
This is for the division bench to look into these type of judgments, not for me.
Sorry, my lord.
I don't look into these type of judgments.
So,
The law is clear.
Clear, my lord, it depends upon the facts also, my lord.
No, no, no.
Fact we
Fact
have-
here is egregious.
Sorry.
Fact. Here you have just for the first one person concerned.
Maybe.
That is 0.25. na?
0.67.
No,
Point-
Not on.
One
on-
person concerned did not like his face. Isn't it the most arbitrary action which has been taken by this person?
There is no allegation.
Ah,
in the
I think
report.
I think rest. I think let
I
me
just
set
think-
aside. No, let me set aside this. Let the division bench take a call. The division bench may be more considerate to the High Court or the district judiciary. I am not.
Lord, may I just
No,
please?
no, no,
Two
nothing.
paragraphs of this.
No, no.
method-
These are on different facts.
No, no.
And tell the division bench, look here, this judge concerned did not look into the judgment of the Supreme Court.
No, 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 my lord.
This
It's
is
not-
judgments are for Supreme Court or for the division bench.
No, no, no.
This is absolutely egregious.
Lord, may I just place
No,
one fact, my lord?
nothing is
Two
there.
paragraphs of
No.
the judgment, but my lord, my understanding of.
No, no, my understanding is different.
My lord, maybe, my lord.
No.
Let me place my understanding.
Nah,
Then
Your
you will also be taken
understanding,
for-
your understanding, you
My
place
lord,
it
will kindly
before the
have para
division
11.
bench.
My lord,
Division bench will understand more.
Lordship will kindly have para.
Two judges, they will understand more.
Sorry, my lord.
There are two judges, they will understand more when you place this judgment. For me, I think it is on the face of it. It cannot be.
I'll just try to place one significant aspect of the matter, perhaps which I could not place on the last occasion.
What is that insignificant?
Before that, my lord, I'll have to place these two paragraphs of.
No, no, paragraphs is later. What is the significant facts?
So basically, this Srivastav judgment says that two lines may read, my lord.
No.
Two lines. Look, it says that how the merit will be ascertained, it's prerogative of the department or the respondent. What criteria they follow. And number two issue is that the criteria seniority cum merit is considered to be infringed when merit was assessed and promotion was given on the basis of inter se merit. Here in this case, merit was assessed, but promotion was not given on inter se merit. Promotion was given on the basis of seniority amongst the persons who qualified.
No, that is what. No, no, this is facts doesn't apply. Let's
No, no.
deliver the.
Look, I'm just coming.
No, no, no,
I'm
not
just-
satisfied.
No,
Not
no.
satisfied.
No, that is
No,
not the judge.
let
about
the
the
division
judgment.
bench. No, no, I think, yeah.
My lord will.
Let me
kind-
dictate.
No, my lord will kind.
No, no,
Lordship will dictate the order, my lord.
now.
At least one
No.
page.
The, I can at least do one thing, say that he relied upon the judgment and I found this judgment to be not applicable. Then you show it before the division bench. The division bench may find it more applicable, let them do it. But for me, no.
Here, my lord, there is no.
This is an egregious action on the part. This particular CGM didn't like his face.
Lordship will derive conclusion, my lord.
And first of all, not only this, not only the petitioner, the other lady also was entitled to be. You have set out parameters which could not have been. It is a case of minimum requirement, minimum merit.
No,
Yes,
no.
yes.
Just please, Lordship will
No.
kindly page 83 of the.
Division bench.
My lord will.
Remaining is division bench.
My lord, the issue is.
No.
I'll just place, my lord.
What is this? Where is the Supreme Court? No, show me one judgment of the Supreme Court of a particular bench strength, wherein it says that for seniority cum merit, you consider merit and not the minimum merit.
Lord,
No,
Supreme
show
Court
me.
judgment
No,
is particular.
no, Mr. Das, you show me that aspect. Show me that aspect.
Lordship
That
will
can
kindly
you? No, nothing.
Appreciate. All right, my lord, Lordship will not turn the page. Lordship will at least hear my submission.
Mm.
My lord, 5 components were fixed,
Mm.
10 marks each. Now, till now, we were, or my lord, I was of the view that this 50 marks was the minimum qualifying mark. in my respectful submission today, this 50 mark was earmarked with the component, 5 component, to ascertain not to ascertain minimum merit, to ascertain the actual merit position of the candidate. And minimum merit is 30% of that. And the educational qualification in which she scored 677, if we apply 30% of 10 marks, it comes to 3. So
How
we-
can they be,
I'm-
no, how can educational qualification be taken on an subjective assessment?
not
It
subject,
cannot be.
we need not go to subjective and
No, no,
objective.
there cannot be. Let me lay down the, whatever it
Page-
is.
page-
You go before the division bench. Division bench may help you. No,
Page
No,
85, if
no,
you also see,
not-
she scored 6 out
No.
of 10,
no,
where she lost, my lord, on objective criteria.
no,
Page 85, my lord, will kindly have a look, my lord.
no.
Page
no,
85,
Nothing.
page 85, only have a look, my lord,
No.
where she lost the game.
Lost the game
No,
is
I'm-
because of the person
My
you
lord,
like.
I am not in anybody's favor, but
You
my.
are, you are,
I
you
must
seem to
place the
be,
facts correctly
you
before you.
are in favor of that person concerned. Where is it?
My lord will kindly have page 85, where she lost, lordship will kindly see. Marks on personality, she scored 3.
Mm.
And reading and understanding skill 2.
Mm.
So far as qualification, she scored 6. She is required only 3.
Mm.
30% of 10.
Why 3?
30% of 10. Educational qualification, 10 marks. She requires only 3. 30% of 10 is 3. So she scored 6. So we need
No,
not go
no,
whether.
how are you deciding this on 3? You are saying your selection proceeding says that you have to get how much?
30.
30 out of 50.
30 out of 50.
So 50 is the total
It-
merit.
Mr. Counsel, kindly see, you don't say 30 out of 30% out of 100 or out of 50. You are saying 30 out of 50, which is means 60%. 60% is the marks. No, I'm asking you.
That's
You
a-
say
that's
that she failed on the ground that on reading and understanding skill.
a higher,
That is 2.
higher percentage.
And
of-
she otherwise passed out there in these other aspects. No, nothing.
So what I'm, Milord, higher percentage of qualifying marks, that's a different issue. For that, Milord, this Srivastava judgment covers.
No,
Distinguish-
judgment
no,
is,
Distinguishing the
judgment
judgment,
does not apply.
no, distinguishing the
No,
judgment.
no,
made by my
no.
friend. But so far as this minimum mark is concerned, Lordship will see, she crossed in educational qualification, she crossed, 3.
Are you saying that 60,
Trying
no,
to-
are you therefore trying to say that it was in the minds of the selection committee that in each of the marks, but not cumulatively, in each of the parameters, a person has to get 60%? No,
Saying,
you are trying to improve.
I'm not saying that,
No,
trying
no.
to.
No, enough. Heard Mr. Esdas, the learned counsel appearing on behalf of the petitioner. Mr. H.K. Das, the learned standing counsel appears on behalf of the Guwahati High Court. You appear? Mr. R. Gohai appears on behalf of respondent of 5 and 6. And Mr. T.R. B. Bokolia appears on behalf of the Judicial Department of the Government of Assam. The petitioner herein have assailed the promotion given to the private respondents by the Chief Judicial Magistrate Hosai by the order dated 24/1/2024 enclosed as Annexure 13 Poly to the instant writ petition. Full stop. The materials on record show it is the case of the petitioner that the husband of the petitioner, namely one Dipananda Bora, since deceased, was employed in the establishment of the Chief Judicial Magistrate Nagaon as a copist First, the husband of the petitioner died in harness, leaving behind the petitioner. Full stop. The petitioner thereupon was appointed on compassionate grounds as a grade 3 copyist Full stop. By an order dated 2/5/2013. Thereupon, the petitioner joined the Chief Judicial Establishment Nagaon as copyist on 2/5/2013. And was subsequently confirmed to her post on 13th of June 2016. On 7/12/2023, the selection board of the recruitment of the Chief Judicial Magistrate Establishment Hojai took steps for filling up of 2 vacant posts of upper division assistants by way of promotion. The resolution dated 7/12/2023 have been enclosed as Annexure 7 to the writ petition. A perusal of the said resolution revealed that it was decided that the board decided by the selection board to adopt the criteria of seniority cum merit, which was which was the mandate of the Assam Chief Judicial Magistrate Establishment Ministerial Service Rules 1987, for short, the rules of 1987. It was further resolved that the existing staff, including the computer typists of the establishments, are eligible for promotion who have rendered not less than 5 years of service as LDA, copyist, computer typist. The head assistant was also asked to prepare a list of eligible candidates for the purpose of promotion to the post of UD assistant, taking into account the 2 numbers of vacant posts, bracket 1 actual plus 1 anticipated on account of superannuation of one Sri Torun Kolita on 31/12/2023, bracket close, and to place the same before the board on the next selection board meeting. The record further reveals that on (19/1/2024), the selection board again held a meeting and passed certain resolutions. The resolution number 1 related to Formulation of the modalities to be followed while conducting the interview for the post of upper division assistant. And the interview board was formed consisting of 3 members, which included the chief judicial magistrate, the subdivisional judicial magistrate, and the, what is that JMMC?
Judicial Magistrate First
First Class for the post of upper division assistant. The selection board further had also laid down the criteria for evaluation of the candidates for the post of upper division assistant by the interview board. A further perusal of the said resolution reveals that the assessment was to be made reveals that the candidates for the post of UD assistants were to be evaluated and awarded marks on the basis of the following yardsticks. First up, the yardsticks being relevant is reproduced here in under. Page 48 of that. A2. Am I? It is also mentioned in the said resolution that the qualifying marks for promotion to the vacant post of UDA would be 30 marks out of the 50 marks. It is interesting to take note of that one of the criteria so evolved was providing marks, 10 marks evolved. Now, one of the criterion so evolved at serial number 4 of the above quoted table is qualification bracket minimum HS passed and higher qualification would carry weightage in marks. And 10 marks have been awarded on the basis thereof. The record, however, do not show the records which have been produced before this court do not, however, show as to how the higher qualification, how the selection board would evaluate the criterion pertaining to qualification as to whether it would be a subjective satisfaction of the member of the selection board, or it would be done on the basis of objective satisfaction. Be that as it may, it is seen that the selection board evaluated all the 6 candidates amongst the 6 candidates. 4 were qualified and 2, including the petitioner, were disqualified on the ground that they did not fail to attain 30 marks. It is pertinent to observe that the petitioner missed out by a whisker in as much as the petitioner was evaluated at an average of 29.33 marks, thereby short of 0.67 to be otherwise qualified. It is further seen that pursuant thereto, the respondent number 5 and 6 were duly appointed to the post of the upper division assistant by orders dated 24/1/2024 enclosed as Annexure 13 Collie, and the petitioner being aggrieved, has approached this court by filing the present writ petition. The record reveals that this court, by the order dated 14/6/2024, while issuing notice, observed that the appointment of the respondent number 5 and 6 shall be subject to the outcome of the writ petition. The respondent number 2, 3, and 4 had filed a joint affidavit in opposition. Apart from stating the facts which have been already mentioned in the writ petition and narrated herein above, it was mentioned that the petitioner participated in the selection process but would not get promotion to the post of UD assistant because she failed to secure the minimum qualifying marks 30 in implementing the criterion seniority cum merit. It was mentioned that the selection board members gave their individual marks on the parameters fixed by the board for ascertaining minimum merit, and after getting the 4 candidates securing minimum 30 marks, promoted them on the basis of seniority which fulfills the criterion seniority cum merit. Full stop. It has been further mentioned that a petitioner having participated in the selection process without raising any objections pertaining to not following the seniority cum merit criterion cannot raise such objection. It was also mentioned that the select list was published in the month of January 2024, and the petitioner approached this court after 6 months in the month of June 2024, which fortifies the fact that her challenge was an afterthought, and she just wanted to take a chance and make an attempt to jeopardize a validly concluded selection process. It was further mentioned that the employer enjoys free play in formulating the procedure to ascertain the minimum merit of the candidates. Further to that, it has been stated that the rules of 1967 and 87 provide criterion for promotion as seniority cum merit, which postulates that promotion will be based on seniority upon assessment of minimum merit. It was further mentioned that there was nothing wrong in fixing the minimum 30 marks as qualifying benchmark for promotion as UD assistant. To the said affidavit in opposition, the respondents have enclosed the individual evaluation being made by each of the three interviewer as annexure R5. It is seen from annexure R5 that one of the interviewer gave the petitioner 34 out of 50 and the other interviewer gave the petitioner 30 out of 50. One interviewer gave the petitioner 24 out of 50. Resultantly, the average of the petitioner being 29.33, thereby missing out from being qualified by a whisker of 0.67 marks. This court further finds it very interesting to take note of a further perusal of annexure R5 gives an shows a very interesting aspect of the matter. In respect to the evaluation done for the criterion qualification, each of the interviewer gave separate different marks insofar as the petitioner is concerned on the criterion qualification. One interviewer gave 6, the second gave 7, and the third gave 8. To the said affidavit in opposition, an affidavit in reply has been filed. Wherein the petitioner not only reiterated the statements made in the writ petition, but also refuted to the statements and allegations made in the affidavit in opposition. It was the specific stand of the petitioners in the said affidavit in opposition, in the affidavit in reply. That the fixing of 30 marks as the minimum marks out of 50 could not have been said to be reasonable, and in fact shows an arbitrary exercise of power. It was stated that the criterion of higher qualification could not have been mentioned, could not have been a part of the evaluation, taking into account that that would amount to changing the mandate of the rules of 1967, which postulates that a qualification to be HS pass only. In the backdrop of the above, this court had duly heard the learned counsels appearing on behalf of the parties. Mr. S. Das, the learned counsel appearing on behalf of the petitioner, submitted that from Annexure R2, Annexure R2, it would be seen that the length of service of the petitioner as on 1/1/2023 was 9 years, 7 months, 30 days. Whereas the respondent number 5 and 6 were junior to the petitioner, were much junior to the petitioner. The learned counsel submitted that though the selection board, as per the settled principles of law, is at liberty to formulate the procedure as well as the criteria as to how the evaluation needs to be carried out for assessing the minimum merit. When the criteria for promotion is seniority cum merit, educational criteria being brought within the ambit of the evaluation and thereby giving higher marks with higher educational qualification would be tinkering with the rules of 1987, which mandate that the qualification is the educational qualification required is HS passed. He further submitted that for the purpose of adjusting the minimum qualifying marks, educational qualification could not have been taken into consideration.
That day we have gone through the rules, my lord. That day we have gone through the rules.
Huh?
In the rules, my lord, minimum HS pass was not there. We tried to find it out in the rules.
In the rules, minimum HS pass is not. minimum
Last
qualification
occasion, my lord, we tried to find it out, my lord. The rules.
Can have the, that is there in the rules, I think on the last occasion I gave you.
What does he say?
It doesn't say anything with regard to minimum
Minimum.
qualification.
But,
I just placed in the doesn't.
And whether the draft rules have been taken into consideration? No. Sorry.
Was formulated perhaps by the selection committee itself, this minimum and maximum. But the rules doesn't say. So.
Okay, look. Mr. Estas, the learned counsel appearing here to 50 marks. But it's submitted. That rule 6.3 of the rules of 1976-87 having not mentioned any educational qualification. To make educational qualification a criterion a criterion for evaluation of the minimum qualifying marks would amount to tinkering with the rules of 1987 and thereby incorporating a condition which cannot be permitted for the selection board to take. That's it, na? That's a submission.
But may I just assist your lordship?
The learned counsel further submitted that even assuming for argument's sake, but not admitting educational qualification could have at all been taken into consideration. But the same has to be done on the basis of an objective satisfaction and not at the subjective satisfaction of each of the interviewer. The learned counsel submitted that if the criteria for educational criteria relating to educational qualification is based upon subjective satisfaction, it would lead to arbitrariness in the actions of the respondent authorities. Referring to the minutes evaluation chart as have been enclosed to the affidavit in opposition filed by the respondent number 2, 3, and 4. As annexure R5, the learned counsel submitted that on one hand, that each of the interviewer gave different marks to the petitioner on the basis of educational qualification. Yes, anything more?
No.
Mr. H. K. Das, the learned counsel appearing on behalf of the petitioner, per contrast, stated that the settled principles of law stipulate that when seniority cum merit is the criteria, the selection board is at liberty to formulate the procedure for assessing the minimum merit, minimum qualifying merit. So that minimum qualifying merit. He submitted that in the instant case, 30 out of 30 marks have been mentioned as the minimum qualifying merit to out of 50 marks. The learned counsel submitted that in the instant case, it would be seen that a combined that the evaluation has been done by taking into account the average of all the marks given by the interviewer, thereby rooting out the scope of arbitrariness or bias. He therefore submitted that this is not a case wherein any interference is required to be made. In that regard, the learned counsel has referred to a judgment of the Supreme Court in the case of Rajendra Kumar Srivastava and others, another versus Samyukt Kshetriya, Grameen Bank and others reported in 2010, 1 SCC 335. And placed reliance on paragraph number 13 and 14 to buttress his point that if the criteria adopted for assessment of the minimum necessary merit is bona fide and not unreasonable, it is not open to challenge as being opposed to the principle of seniority cum merit. The learned counsel further submitted that the prescribing the minimum qualifying marks in the instant case, further submitted that in the instant case, as would be seen from the materials on record, that after making the evaluation, it was found that out of the 6 candidates, 4 have secured more than 30. And thereupon, on the basis of seniority, the promotion was made to the post of upper division assistant in terms with upper division assistant. Amongst the persons who have qualified and obtained 30 marks. I've heard the learned counsels appearing on behalf of the parties and perused the materials on record. The judgment placed by the learned counsel appearing on behalf of the respondents in the case of Rajendra Kumar, Mr. What do you want to submit? You adopt his argument. Mr. So-and-so, who appears on behalf of the respondent number 5 and 6, submits that he would adopt the arguments as well as the pleadings of the respondent numbers 2, 3, no, the respondent number 5 and 6 would adopt the pleadings in respect to the pleadings of the respondent number 2, 3, and 4, and further would adopt to the submissions made by Mr. H. K. Das, the learned counsels appearing on behalf of the respondents. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. At the outset, it is relevant to take note of clause 6.3, rule 6.3 of the rules of 1967, which stipulates which deals with filling up the post of upper division assistant. Clause 6.3, rule 6.3 of the rules of 1967 being relevant is reproduced herein under. From a perusal of the above rules, it would be seen that the promotion is required to be made, that the post of upper division assistant is to be filled up on the basis of promotion, on the basis of promotion from amongst the lower division assistants of the Chief Judicial Magistrate Establishment Ministerial concerned. By adopting the criteria of seniority cum merit, and amongst the persons who have not rendered less than 5 years of service as a lower division assistant in the Chief Judicial Magistrate Establishment concerned on the first day of the year in which the promotion is made. Therefore, it would be seen that the criteria on the basis of which the promotion is required to be made is seniority cum merit. In the case of D.B. Sivaya versus D. Adanki, Attanal, Babu, reported in 1998, 6 SCC 720. The Supreme Court, while explaining the difference between the principles of merit cum seniority vis-a-vis the principle of seniority cum merit, held that when it comes to the principle of seniority cum merit, the promotion is to be made on the basis of seniority alone, subject to having the minimum requisite merit and suitability of the candidate amongst the eligible candidates. Persons. It was categorically observed that the principle, the criterion of seniority cum merit postulates that given the minimum necessary merit requisite for efficiency of the administration, the senior, even though less meritorious, shall have priority, and a comparative assessment of merit is not required to be made. It was further observed that for assessing the minimum necessary merit, the competent authority can lay down the minimum standard that is required and also prescribe the mode of assessment of merit of the employee who is eligible for consideration for promotion. Such assessment can be made by assigning marks on the basis of appraisal of performance, on the basis of service records and interview, and prescribing the minimum mark which would entitle the person to be promoted on the basis of seniority cum merit. The Supreme Court further emphasized in the same judgment in the case of B.V. Savaya Supra that while taking into consideration the criteria, the principle of merit cum seniority, the requirement is of making a comparative assessment of merit. It was observed that since comparison assessment of merit is required to be made while applying the criterion of merit cum seniority, and for seniority cum merit, no such comparative assessment is required. It was observed that the principle of compared merit cum seniority postulates the requirement of making a comparative merit assessment of merit. from the same judgment of the Supreme Court. It is clear that the emphasis have been duly laid down. On the aspect that where the criteria of promotion is the principle of seniority cum merit, marks can only be prescribed as a minimum qualifying requirement. And as such, where the promotion was being given to eligible seniormen on the basis of their individual marks, such promotion could be contrary to the principle of seniority cum merit. Court further finds it pertinent to observe another aspect, another judgment of the Supreme Court in the case of Rajkumar and Chuklal Maheta versus High Court of Gujarat and others, reported in 2024 SCC Online SC 972, wherein the Supreme Court, while dealing with another judgment of the Supreme Court in the case of K. Samantare versus National Insurance Co. Limited, reported in 2004 9 SCC 286, referred to another concept of promotion, known as inverted comma hybrid mode of promotion. It was categorically observed that this hybrid mode of promotion is distinct from the principles of seniority cum merit and merit cum seniority. It was observed that this hybrid mode of promotion in this criteria of hybrid mode of promotion, the requirement is that the seniority is to be duly respected and the merit appropriately recognized. This court is referring to this principle of hybrid mode of promotion, taking into account that from the materials on record, it is like to be certain. Let me come back in 5 minutes to allow your activity with cost. This third mode, that is the hybrid mode of promotion, at paragraph number 10 and 11, and the same being relevant, is reproduced here in under. In this third mode, from the above quoted paragraph, it is seen that in this third mode of promotion, in this hybrid mode of promotion, it is open to the employer to specify the area and parameters of weightage to be given in respect of merit and seniority separately, so long as the policy is not a colorable exercise of power. Nor has the effect of violating any statutory scope of interference and other relatable methods. In this hybrid mode of promotion, it was permissible for the employer to have their own criteria for adjudging the claims on the basis of seniority come merit, giving primacy to merit as well, depending upon the class, category, and nature of the post in the hierarchy of the administration and the requirements of efficiency of such posts. Stage, this 4 point is very pertinent to observe that there is a distinction between seniority come merit simpliciter with that of the hybrid mode of promotion. Inasmuch as in seniority come merit simpliciter, the requirement is only to find out the minimum necessary merit to man the promotional post. In the backdrop of the above, let this court now take into account, now look into the, now take note of the minutes of the selection board of recruitment held on 19/1/2024. And the criteria evolved for evaluating the qualifying marks for promotion to the vacant post of UD assistant. A reading of the entire resolution would not show. A reading of the entire resolution would only show that the candidates for the post of UD assistant are to be evaluated and awarded marks on the basis of the yardsticks. And if the candidates obtain 30 marks out of 50, they would be qualified for promotion. In the previous segments of this instant judgment, this court have already quoted the table whereby the criteria as to how the 50 marks would be evaluated have been mentioned. It will be seen from the evaluation criteria that the selection board have adopted instead of adopting adopting a criteria for the purpose of evaluating the minimum requirement minimum qualifying marks have rather adopted a hybrid mode of promotion thereby giving weightage on certain criteria, which in the opinion of this court would not have been done so. In this regard, this court finds it again pertinent to take note of Rule 6.3 of the rules of 1987, which do not postulate a qualification for manning the post of upper division assistant. However, while making that evaluation criteria, qualification has been incorporated as one of the criteria. It is therefore the opinion of this court that the respondent authorities, more particularly the selection board, have adopted a criteria for promotion which is not in consonance with the principle of seniority cum merit, which only aims at evaluating the minimum qualifying marks as at merit. This court, the instant matter can be taken from looked into from another angle. And more particularly looking into the assessment so made upon the evaluation. By the three interviewers. It is seen that the interviewers did not, even prior to in the opinion of this court, qualification could not have been brought within the ambit of a criteria for the purpose of evaluating of the minimum qualifying marks. Even otherwise also, if the qualification could have been brought, then also there has to be an objective satisfaction and not on the basis of a subjective satisfaction of the interviewers. The lack of parameters to evaluate the qualification criteria is apparent from a very perusal of annexure R5, wherein it is seen that each interviewer have given separate marks, have given a different marking, in respect to the criteria for evaluation. This aspect further shows complete non-application of mind on the part of the selection board. In the backdrop of the above analysis, let this court now take into account the judgment of the Supreme Court in the case of Rajendra Kumar Srivastava Supra, as have been placed by the learned counsel appearing on behalf of petitioner respondents, and more particularly laying emphasis in paragraph number 13 and 14. Perusal of the said judgment would show that if the criteria adopted for assessment of the minimum necessary merit is bona fide and unreasonable, it is not open to challenge. But the question arises as to whether in the instant case, the action on the part of the selection board can be said to be bona fide and unreasonable. Or is it on the basis of, is it, or is the action on the part of the respondent selection board aiming to find out the minimum assessment of the minimum necessary merit? Or is it an assessment of merit by giving due weightage to various parameters? The answer to the same would be that in the instant case, the selection board took steps to ascertain the assessment by giving due weightage to various parameters of merit rather than an assessment for minimum merit, necessary merit. Under such circumstances, the judgment of the Supreme Court in the case of Rajendra Kumar Srivastava would not help the case of the respondents. Considering the above, this court therefore is of the opinion that the impugned selection proceedings requires to be set aside and quashed. Accordingly, the selection proceedings mandated, accordingly, the selection proceedings made on 22/1/2024, thereby selecting the respondent number 5 and 6 to the post of UD assistant, requires to be interfered with. Next. The writ petition accordingly stands disposed of with the following observations and directions. The minutes of the meeting dated 22/1/2024, thereby holding that the respondent number 5 and 6 are required to be promoted to the post of UD assistant is set aside and quashed. Number 2, the order dated 22/1/2024 issued by the Chief Judicial Magistrate Huzai, whereby the respondent number 5 and 6 were promoted to the post of Upper Division Assistant in the establishment of the Chief Judicial Magistrate Huzai is set aside and quashed. Number 3, the orders dated 24/1/2024 issued in favor of the respondent number 5 and 6, thereby promoting them to the post of Upper Division Assistant. Bracket Annexure 13 wholly to the writ petition stands set aside and quashed. With above the instant writ petition, anything more?
Will there be any direction for press?
Oh, let them not do it.
19-1 will remain, my lord. 19-1 will remain.
Which one? That I'm not bothered. I've already said that the parameter is wrong.
That's
You have gone into the question of hybrid mode of motion.
my lord.
Let the division bench look into it now.
Highly obliged.
Much okay. Deeply okay.
Yes, Mr. Bush,
My lord, 2 weeks time, my lord.
why?
My lord,
Isn't the case of provisional pension?
my lord, what happened? My lord? We have already paid more than 15 lakhs towards DPS, AIS and all. And where the process is on, my lord, he'll get my.
No, tell me, whether the rules of 1969 is not applicable in the case of the petitioner? No, tell me. If it is not applicable, very well. Or should the High Court or the district judiciary has an exemption to the rules?
And the DP is.
Rule 22,
Rule 22.
isn't the Rule 22 the mandate of law? Or it does not apply to the High Court? High Court is above the law. No, tell me, maybe. High Court may be above the law as they are deciding matters. I see the notice issued on 2010 line.
10 September.
Yeah,
Yes.
taking into have not been paid the since 1/4/2024, and attempt shall be disposed of the restitution on the next day. Learned counsel on behalf shall also apprise as to what is the status of the present department. The
My lord, DP is pending. And the inquiry
DP is pending, but what is the status?
my lord, inquiry officer has been transferred. Inquiry officer has been transferred, my lord.
Has been?
Transferred, my lord.
Actually, inquiry officer's post, lordship, additional district and sessions judge post has been lying vacant for a period of more than 4 to 5 months.
My lord,
Hence, the DP has not proceeded further.
my lord. That is the
Which district?
It's in Kokrajhar.
Kokrajhar district.
There is no district and session judge.
There is a district and session judge,
Then
the main disciplinary authority, lordship,
who is the main disciplinary?
district and session judge.
He's not there.
She is present, lordship.
IO was appointed as additional
Yes.
district and session.
Then,
And he was transferred, man. And that post is lying vacant, man.
so,
The district judge is,
so can that be at the peril of the authorities? We cost
my lord,
you paid for quashing of the departmental proceedings or not?
No.
On
lordship.
delay?
No,
no,
lord.
he is
What,
not
what,
paying
what?
that.
You should quash it. Isn't it the Supreme Court saying that there should not be delay in departmental proceedings?
Yes, true, lord.
It cannot be at the whims of the department authority. Isn't it?
Yes.
My lord.
He said
the
the departmental proceedings,
No,
then
no,
he gets the final pension.
Allegation against the petitioner is very serious.
What
My
is
lord,
the-
what
what
if-
is- what
my
is
lord-
the allegation?
My lord, what happened, my lord? 5 grateful employees were appointed. And out of that 5 employees, 2 employees, all the 5 employees were approached by the petitioner. And out of that 5, 2 employees were declared as overqualified. And the petitioner went to their school with the constable, collected their admit card result and all from that school. And he initiated these things
Lordship,
to establish that, and he demanded 2 lakhs from the complainant, and he collected from other people 20 lakhs. Madam. This is the allegation filed by that grateful employee
lordship,
against the petitioner.
this complaint was
In the name
given
of the
after
district judge,
termination.
madam, he collected that.
This complaint was given after that termination, lordship. In the
After
month
the-
of, after that termination, due to misrepresentation. In the month of December,
my lord,
after 3
when-
months
when
later,
This
The termination.
yes, 3 months later, after the termination, which happened in the month of October, they filed this in the month of December. This is an aftermath, lordship. They filed this complaint aftermath after the termination.
Or termination of those grateful employees.
Yes, to grade 4 employees.
2 other overqualified employees are working because they paid to him according to the complaint.
Lordship, he has no authority itself. The
That's a different issue.
appointing authority is district judge, lordship.
Who are you?
I am the chief administrative officer, Sirastadar, in the court.
The complaint is in the name of the district judge, he collected them. Whatever, that is the serious allegation, my lord. We are not on that, my lord. 2 weeks time, my lord, we will file that. And
No, but then also, is it the mandate of law you don't pay the provisional pension? I'm only asking that.
Then we are going to pay, man.
Because he has not got it from 24. 1 year has passed by. How is it?
Very true, my lord.
Then
I had a discussion with.
he's not asking for the final pension. He's
Yes.
only asking for his provisional pension.
Yes, sir.
But is it the mandate of law that a departmental proceedings is there? However serious, which is the question to be proved in due course, or for the High Court or the District Judiciary, the Article 21 is not there. The procedure established by law is not applicable. Tell us.
My lord, we
that
are going to
High
pay
Court,
the
High
provisional
Court
pension.
as well as the District Judiciary is exempted from Article 21. Isn't his right to life?
Provisional
getting-
pension has to be paid.
Getting a provisional pension pending departmental proceeding is the law as per 22.
Yes, ma'am.
So you cannot deprive him unless you show something.
No, my lord, that part is there, my lord, I cannot improve it, but we are going to pay very soon, ma'am.
You are going to pay.
Pay, ma'am. And,
When?
my lord, I am paying for 2 weeks time, my
No,
lord.
no. 2 weeks time for filing affidavit are going to pay. It
My
will-
lord, they have initiated as per my instruction.
Huh?
As per my instruction, process is on,
So what? Process is on.
my lord.
Should I record it? In the order the process is on and you are going to pay. Just tell me.
We are going to pay, my lord. That may be the case. We are going to pay.
You cannot.
I-
stop him
I'll make-
Because it's a right to life.
Yes, my lord. But facts remain that we paid him more than 15.
How?
Towards GIS and general provision.
General provision fund, that means provisional pension he is not entitled to.
No, man.
Then
He's entitled.
how is it responsible?
But-
General provision fund, a person works all this while and this general provision fund is not your money. The money has been deducted from him, isn't it?
Yes.
Then you are giving him back his money along with the interest. That's all.
Leave encashment and all.
You're supposed to be disposed of
Ye-
today, isn't it?
Yes, Lordship.
Next day only.
Every time we approach, they say that it's in process, and for the last 1.5 years.
Process cannot go on like this, too slow. Okay, we have it on 13th of November.
Lordship.
Mr. G. Boyce submits that the affidavit could not be filed on account of the lack of instructions.
No, man. We have received the instruction. It is on waiting state.
His affidavit could not be filed on the ground that the affidavit is at the stage of waiting. Be that as it may, this court inquired with Mr. G. Boyce, the learned counsel appearing on behalf of the respondents as to whether the petitioner is not entitled to the provisional pension pending disposal of the departmental proceedings. The learned counsel submitted that taking into account Rule 22 of the Assam Pension,
Assam Service
that
Pension Rules, 1916.
name,
Assam Service Pension Rules, 1969.
Assam
Service Pension Rules,
Service
1969.
Pension Rules 1969. Petitioner would be entitled to provisional pension and the same is under process. This court further inquired as regards what is the status of the departmental proceedings. It was submitted that on account of the inquiry officer having been transferred and the post lying vacant, the departmental proceedings have not progressed. Considering the above, list this matter on 13th of November 2025. Pusto. The affidavit be filed on or before 12th of November 2025. The respondents shall also take effective steps for dispersal of the provisional pension to the petitioner on or before the next date and give an update before this court. To effective steps or towards the dispersal of the provisional pension to the petitioner and give an update before this court on the next.
Obliged.
May it please your lordship. My lord, in pursuance to the order dated 18/9/2025, Mr. Director of Prosecution has to submit some report. Para 4, your lordship, kindly see order dated 18. এইটো আমাৰ আগত না 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 কিন্তু
Here notice the last occasion you notice one list is provided by the Register of the High Court, Mela. And the list which have we have acquired, Mela, we have consolidated well, the total we have found 78 people instead of 72. And out of which, Mela, 2 have been disposed of, now 76 is still pending. Special case,
এইটো state by High Court এখন
they to disposition. 2013 case. Yes, 18 case, 2023 was again. 23.
13 হবই নোৱাৰে
23 over.
লিষ্ট
No, police. No,
Serial number 29.
my lord,
কুকুৰাঝাৰ
lordship.
This is disposed of.
I think is for necessary order, yes, 10,
30, 10.
30, 10 yet to come,
My lord.
30, 10 probably fixed for CAB.
No, 30, 10, 2025. That is already come.
That will come in next week probably.
No, it is the 10th. Because so far related to the single bench, my single bench, only one matter.
One matter left. No, so far as High Court cases are concerned, no problem, that can be sorted out, my lord, probably considerable progress has been done in the case pending before the High Court.
But it seems Morigaon.
High Court কেটা আছে না?
Morigaon, two cases, my lord. One is disposal. And one is stayed by the High Court, and next date fixed on 8th year of for it.
এখনের হাইকোর্ট দুটা বেলেগে নাই আছেন অবশ্যই ডিটেইল কোর্ট ডিটেইল নাই যদিও ডিস্ট্রিক্ট লেভেলত ডিসপোজ অফ হ'ল সেইটো হাইকোৰ্ট এপিলত আহিব না আকৌ
What is the status of CR 1202/2017? Serial number 76.
My lord, next date, it shows, my lord, next date fixed on 1/11 of 2025.
This date is fixed by High Court or the trial court? 1/11.
My lord. This we have to verify, my lord. But it is not 2013, the last column is available.
Ah, that.
2025
Case disposed of 2025, but this one is 13. My lord.
That will be 2000. Maybe 2020. Now, how do we do it?
My lord, these are the suggestions, my lord, I have prepared, my lord. Last occasion direct to me, my lord, prepare some suggestions for that. These are the suggestions.
Mr. Mohanta,
it's my lord
I was just discussing with my brother. In cases of more particularly those complaint cases,
My lord.
where no steps have been taken or why action is not being taken by the magistrate under 256?
250.
Because isn't it the requirement of law? The language of 256.
256. Shep.
If the summons have been issued on a complaint and on the day appointed for appearance of the accused, or any day subsequent thereto to which the hearing may be adjourned, the complainant does not appear.
My lord.
The magistrate shall, notwithstanding anything contained herein above, acquit the accused unless for some reason he thinks it is proper to adjourn the hearing of the case to some other day. The complainant represented by the pleader or by an officer conducting the prosecution, or whether the magistrate is of the opinion that the personal attendance to the complainant is not necessary, the magistrate may dispense with his attendance.
He
So
can,
if that be so,
He can.
it is the mandate of there, where no steps have been taken.
is someone's case.
Why action is not taken under 256 and finish it off?
He can, my lord. Is someone's case, he can.
Correctly.
Someone's case.
And in the case of Warren, then 249,
240.
but the 256 language is very clear.
My lord.
The word we use is shall.
My.
So isn't it the necessity? Because there are many cases where I think it must be cases of defamation.
Because of
and
the- yes.
Majority of the reasons is no steps have been taken.
Taken by the petitioner.
So no
Complainant.
steps have been taken where no action is taken under 256.
Someone's case of funny. Look it up, no, that has a policy. So 259 level. We are লিখে রাখছি লিখে বস্তুটা।
All these cases, this,
My
for
most
example,
clear difference.
serial number 32 onward, 32 to 35, it appears to be all complaint cases.
Yes. CR case, yes, appearance.
Necessary orders and all. But the last information which we got is that these matters, no steps have been taken
By
on
the petition, complainant.
it too. This list is not corresponding to this list which you have provided is not corresponding to the list which he has given, huh?
Yes, my lord. The list which was given by the my lord, the registrar of the High Court, I have my lord compared with my list, my lord. Then we have found all these things, my lord. Total 78, my lord.
Your list is of 31/8.
31/8, last one is
Last-
31/8/25.
So let us see as regards Dhubri. Dhubri, where is that serial number? Dhubri.
Body, my lord.
That, for example, at serial number 15 of your list, Kamrup Metro CR 3242/2014 report. Reason for delay complaint has been absent after 19/9/2016.
My lord.
No steps of warrant against the absentee accused are not taken.
So steps not taken by the complainant, yes.
But then here, if it's a case of, so is it a case of warrant or summons? Warrant then 249
Is someone then 256?
and warrant 49. 249.
Absence of complaint. When those signatures been included upon the complaint on any date except for hearing of the complaint in absent.
বেশি কোনটা? কোন section?
Only for the not,
ইমান নাম section
then he got and then he got with them is something.
Here it can
But it's
steps of warrant.
before SARS.
Here's that, therefore, steps of warrant against the accused section is. The warrant against. Come on. This could be,
250. order pass কৰি দিবলৈ কাৰণে যিবিলাক pending আছে state লোৱা নাই। order pass কৰা। And in respect of the complaint case hold in absence of the complainant, my lord, then your lordship kindly specific order may be passed, my lord, because they are actually probably Lanet Magistrate, trial magistrate, giving it time one after another, my lord.
and if the witness is not coming,
Witness is not coming, my lord,
then what to do?
then
Can you have it for all time to come? If the witness is not coming, then you
then
cannot-
whatever the available, then you can proceed with the one.
It has to be closed, that evidence of that particular witness has to be closed and you have to proceed next.
Yes, no,
Because the mandate of law is speedy trial.
my lord, spirit trial. No, suppose, my lord, there are 4 evidence, 2 evidence already come, and on the basis of that 2 evidence, my lord, he can proceed with, my lord.
If they don't, yes, reasonable opportunity
Yes,
has been given.
at
Just
least-
for example, if you see particular thing, at serial number 18,
My lord,
GR case number 3629 of 2015, witness not appearing.
witness not appearing, yes.
If
Here,
the witness
it is
is
here
not
case.
appearing, the court has to proceed. Or can it
Yes.
be kept on prolonging?
No,
Isn't
that
the
cannot be.
duty?
Cannot be, my lord, it kept in prolonged, my lord, kept in a long period, my lord.
If they have feel aggrieved by the order of the learned magistrate, they can approach the minority.
High Court
Yes.
and give opportunity
Yes.
for that. But you cannot prolong the trial.
Prolong
for
the
that.
trial.
It has to come to an end. Now here, 19, GR, IO is not appearing. The IO is not appearing, what to do? Either the director of prosecution has to take appropriate
Action.
steps for the IO to appear. Or if he does not appearing, the court has to proceed, there is no evidence. And close it.
Yes, that can be.
But the law does not permit, this is a set of procedures. Procedures have been given.
And serial number 3. Accused are not appearing since 2023.
Then
Issue warrant or do something. Serial number 3.
In fact,
Who
they
do
are
not know?
not discussable, but
Who do not know? Who is the
So-
company?
serial number 3, I have seen, my lord.
Yes.
No, no.
Even notices
We-
issued
we
without
not-
any address,
we-
then also
we
is,
do
my
not
lord.
Go by the names.
Even, my lord, without any address, my lord, it also is, my lord. If your lordship stand with me.
it can't be of the
This is-
2008 pending like this.
This is a defamation case.
And moreover, my lord, NBW was issued in the-
Arrest. What are you doing?
And
If everybody can identify by the name, is it any difficulty for police?
Yes.
It appears that when NBWA has been issued, then in that case, and these 2 persons, if they can be identified and not arrested, the police is lacking.
Not.
Bring them.
So rule of law has to be followed, my lord, because whoever may be,
It's the rule of law at the end of the day.
my lord.
Means first of all,
Serial number 4.
same,
Same,
both the cases together.
Together.
Yes.
They are not appearing. means-
2982, 2982, 2981, yes,
Yes.
2981, 2982.
298. 2008 case. And next date
Serial number 6.
And these are defense at the stage of defense witness.
Defense witnesses.
Now, if it is at the case of
Then
defense
defense
witness,
has to be
It has to be closed and then proceeded for arguments. Then it has to be appeared by the pleaders. Or they may argue.
So, my lord, I think, my lord, it will be proper.
Because the arguments, I don't think is a part of the trial. It is imbibed in the trial.
My lord,
Means when you make an argument, like it has been in a CPC, arguments have been brought within the ambit by way of a written argument. If you see Order 18 Rule 2A,
my lord.
is argument a concept in the CRPC?
CRPC
Argument? I
argument,
don't think. Argument
No.
is not a concept.
argument.
The trial ends where? Evidence is given.
Yes.
After that, what is there? Defense statement is given, then if they want to lead the defense.
No, then 3 on 3, then my lord. It's all normally fixed for argument, my lord.
No, it is fixed for argument, it is different thing. But
Right.
is that the concept in the CRPC? Don't think so. Maybe in the BNS.
Right.
And see serial number 8, anybody from
Nia?
Can it be ground? It has gone.
Okay. Doesn't clear.
Concept of argument assignment. Trial of hip-hop, trial of hip-hop.
Okay, preliminary rules and orders.
Argument of option to put. 3-1. 3-1. T1 4. Two 30.
Well, Mr. Fukan, the point is like this, in those two matters which he has referred, my learned
330.
brother has referred to, at serial number 3 and 4.
My lord.
This person, upon the trial being initiated, they must have gone for bail.
Probably, my lord, because my lord, they are on bail, my lord.
They are on bail. We cancel those bail.
Would be put a session.
For the bail. If they are not appearing, this has to come, this can't continue in this manner.
Mr.
Come to 9 and 10 special vigilance.
Yes, 9 and 10.
Missed it.
Lakhimpur.
Then serial number 7, this is not with SAR.
In this regard, my lord, I have already conducted many meetings, my lord, CC meeting with the SPs, SSPs and the DPs. The direction which was, my lord, given by this honorable court, I have already advised all the SPs. Take immediate actions, those who are not executed the summons and the warrant. And they are agreed.
9 and 10,
Oh, yes,
prosecution
yes,
witnesses are not coming.
My lord.
If witnesses are.
Here, my lord, 9 and 10, Lakhimpur special vigilance.
The trial of a
It speaks for evidence. One is special vigilance 6/2012 is for IO evidence and next date fixed on 29/10. Man.
1 minute, sir.
I think this case is also over, serial number 13.
The special just CBI, madam.
2013 case.
Yes, it is by the
Where stay was granted in criminal revision number 4152. What happened to this case? What is the present status of this cases?
CBI to PF, madam.
Criminal revision petition
CBI case.
415760 and 813/2000.
Special case shared with the client.
2013 special case. I was on the other one.
Criminal revision itself is of 2014. What is the status of this? Because ask somebody immediately can be found.
My lord,
Criminal, serial number 13, criminal
Yes,
revision
to my
petition
son.
4156.
my lord, let me read. 3 of 2013.
Status of criminal revision numbers 415/2014.
Criminal division 415.
2014 altogether 760 2014 and 813 2000.
Criminal division. Yes, my mind, let me add. My lord, so far his argument is concerned, 314 is there, my lord. 314, my lord. After 313, there is a provision, my lord, oral argument and memorandum argument. 314. Before the.
May, any party may, as soon as may be, after the close of evidence, address concise oral arguments and may before here. So they may or may not.
May or may not.
So this is similar to that, as I said, order 18 rule.
Yes,
238.
and before the session court, that is my argument, 234. 234 miles. CRBC.
It is okay as regards
Mine.
sessions, we consider it okay. These are another form of, these are session tribal cases where the certain things we can only go
By the
forward.
trial.
As regards these matters wherein first the bail has to be cancelled. He has violated the terms of the bail.
My lord.
So the court has to take appropriate action in that regard and call the bailer
Yes.
to produce him. And if the bailer is there, then the bail has been, bail bond has to be. Some proactive steps have to be taken by the court.
That's what the. Huh? Good disposal, funding company.
So this is disposed of.
Dispose of. Dispose of that is.
That criminal revision.
There's two disposal.
Then what happened now? There is no online order because at that point of time.
Order was not up to this.
So this is to also to be updated.
Yes, yes, my lord. Yes, some of the high court cases are, I have seen, my lord, probably only 3 or 4 cases left in high court. That too, one is, my lord, fixed for probably the month of October 30th month. Last order করেছে ও ডিসপোজেবল করতে পারে order is not uploaded but case is disposed of, indicating that case disposed. That's side indicator. Dispose of her. Step from. No, no, I could have taken that for you. Rule of statistic, mistake লাগে হাওয়া না করে।
এইটো মানে কিবা এটা যদি গাইডলাইন বান্ধি এই সাজেষ্ট কৰে যিটো মতে যদি ভিডিঅ' তুমি কাম কৰিব নথিব
এখন কেতিয়া পড়ানো ঠিক আছে। তিনটা শো করছি এটা কোনো কৈছে
প্ৰথম পেজ
তাকে
So Monto, I think we need to update.
update the at least na high court list been made properly, but here my lord is the your lordship serial number 13 my lord 3 cases are listed, only one shows that it is disposed of 415.
This is a common judge.
Maybe for the three common judgment. No, so far is my lord high court is concerned, my lord, yeah, it will be no difficult to update the my lord.
Sir, we have the list
My
out
lord.
here. You have given as of the list of the
31
8
8.
2025. We'll ask your junior to give us details as
My lord.
regards which are the complaint cases wherein
He'll
it
say
is
again.
being stalled on account of the non-appearance of the accused, not the accused, the complainant.
My lord,
Or not taking steps.
Or not taking steps.
Yes, my lord.
So then, we propose to fix another day whereby indicating or the purview of, because one thing one has also to take note of that we are actually not sitting on appeal or revision
Yes,
against
we are
the
monitoring
proceedings.
only.
We are monitoring.
Monitoring only.
So
We
therefore,
pass the order.
we can very
Both
well make observe what is 249 and what is 256 in the
256.
scope and ambit.
And do the needful. Then
And no, and then after stating that, we can very well say, ask the registry to and place a copy of this order before the concerned judges wherein the matters are pending and seek a report as to why action under 249 and 256 have not been
not been
received.
taken. No, that will be, I think, appropriate, my lord.
That is
So
the
let me,
only
my lord,
way.
he has some-
By explaining what is 249 and 256,
My lord.
that is one. For that, we ask your
My lord.
junior to give us the details so that in
Here
that
to it.
order, we can specifically mention about these cases. That is one. Secondly, as regards item number 3 and 4. 3 and 4.
3 and 4. No.
Because we can't take up all the matters today. 3 and 4, we observed that what steps have been taken, and whether these persons were in bail. Whether bail has, what steps have been taken, whether the bailer had been called for the purpose of producing him, taking into account that these persons are not appearing after taking on bail.
Bail. So bail has.
Non-bailable warrant of arrest has been, if it is being issued, why the authorities have not taken steps for it? So we asked them, let them submit a report on. এইটো কথাটো NBWA নহব নহয়। NBWA notes, okay, but you can't complete because he's on bail.
Yes.
Because
definitely.
we
After appeal, he has
need
to
not
take
go into the question of NBWA. Maybe the steps have not been taken
taken.
by the complainant, and because of that, nothing has happened. But at the end of the day, the proceedings are pending.
Yes. Proceeding
So
up-
therefore, if it is a complaint case, he must have gone on bail. And if he has gone on bail,
There is
why
a bail-
no steps have been taken for the purpose of
Cancel the
asking the bailer,
to produce him.
produce him. This is the direction. This is one of the undertakings being given.
Yes.
And we can, the moment the bail is cancelled, it becomes the duty of the state on its own without the steps being taken by the complainant for getting him,
Getting.
isn't it?
Yes. ma'am.
So I
That can be
think
done, ma'am.
in 3 and 4, we take that step, pass that specific order, and in
so-
respect to all others,
he'll do it.
he will give a list. We fix the matter sometime in the month of November.
Ma'am.
November 19th, 20,
My
20,
lord, no problem. No.
20, so that we can get an update.
Update, ma'am.
We will make the judges knowledgeable as what is 249 and 256, and I hope and expect they will exercise such power.
We follow into 56 and
We are not to do that because we are not
Ma'am,
sitting on
every day.
revision, but as a monitoring bench, we just, let's sit down.
And so far relating to non-production of
Witnesses.
prosecution witnesses.
My lord.
What
So
steps
IO is
the
not
state-
produced.
State has taken.
Some
Who
cases
will
I have
give
seen,
us
I was not.
Those
produced.
cases, that is your
My
responsibility.
lord.
These are the cases and you will.
Yes,
give an
sometimes
actual
what happened, my
status
lord, I was
that,
declared.
What is the actual status as well? You have given suggestions, good suggestions.
My,
Till we convert into a judicial order your suggestions, what are you proposing or what? You should do something that you, these are the cases, give the list to them.
my lord. I'll do it.
Because Mr. Fukon, it cannot go on eternity, the matter, because of the fact that some witnesses are not coming.
My,
If you are not in a position to produce, because as per the law, once the trial starts, it has to go on a day-to-day basis. The concept of going for time, short adjournments, the concept of short adjournments is also, it is, you have to give due reasons why you are giving a short
Short-
adjournment. Otherwise, once the trial starts, it goes on a day-to-day basis. If you are not in a position to provide the witnesses, the action where the law would take its course. So it can't remain pending like this forever. So we'll pass an order to that effect.
My lord.
Huh? You give,
Lordship. No. Short up কৈ দিম তো listing মানে।
and we will ask for an updated list on the next date. You have to give an updated because certain aspects have not been properly taken and also look into the list which he has also given.
Yes.
Huh? So we will have a look at.
After him, give that, one can also give which are those cases, serial number
my, lord.
against their, or in your case also,
My lord, yes, sir.
which are those cases, both of will take together and
My lord.
will incorporate those cases
Lordship.
into our.
My lord.
We'll incorporate those cases
My lord.
specifically. Then only those particular and the court. court which is pending, then only the registry can provide that copy
Yes.
of our order to that court, no?
Correct.
All right, he will do it, my lord.
March of it.
And a copy of your order would be given to the PP. Who is your PP? No PP. Somebody has to be given. You are not here, so somebody would be given so that you can take do the needful.
No,
We'll
issue,
give it
on
to the
that day I
people.
will press, I'll come back.
No, no.
In the meantime.
The registry will give the order,
the
no?
order. We'll ask them to deliver.
Yes.
Copy to.
Last occasion, my senior government advocate has given me that.
You are?
Additional public prosecutor.
It can be given to her
My lord.
so that you can do the.
Not, March of it.
Like, Khalil, he will do it.
But we can pass
Within-
this and
within-
upload this order subject to your
Yeah,
providing.
Give it during the day. Yes. They will give it during the day. You will also give it during the
Okay, my
day.
lord, no issue. My lord.
Oh, the day is ending at 4:45. It's a long time. We have dispensed with your service at 2:45. 2 hours. We need not further prolong and take up the next matter, Mr. Khan.
Well,
For orders item 2.
March of it.
develop. ED.
What happened to the chief judicial thing, magistrate?
Look, two sets of, look, 3 reports are there.
Ah.
As per your lordship's direction on the last occasion. If your lordships kindly come to your lordship's order. Last order, para 12, last portion. We direct both the registry as well as concerned official of the state of Assam to place before us a complete proposal for accommodating the lawyers practicing in the establishment of chief judicial court, keeping in mind their safety and the infrastructure should be conducive for working. প্ৰথম আছিল
Yes.
এইটো ক'ত আছিল
Yes,
Lordship
Mr.
will
Bhumika,
find-
anything on this aspect?
My lord, in fact, my lord, it's there in the report of.
1710, 171025.
Just after the chart, man, they've given 3 options. So mechanically, after the chart.
Dated 171025 million. It's a communication from executive engineer PWD to register it. এটা রয়ে গেছে
What can you do? What will you do with the new building if you make it? Because we are concerned about one thing. There is a move of the judicial city to be judicial infrastructure to be set out in Rangpur. If that be so, to have a construction of G+4, where after all it is public money also.
Yes.
You have to be, keep in mind that. So if that be so, how do you take care of that building later on? Because it has to have, cannot only be only for the purpose of this
Yes.
3-4 years you are going to have it. And thereafter they demolish the building.
Option number 3, Lord, you will see they said that, my lord, it will be a steel structure. Mainly steel composite structure. It can be thereafter dismantled.
তিনিশ পঞ্চাশ চাৰিশ 350 400
আৰু এই লাইনটো চা লাষ্টৰ এই লাইনটো নহয় actual requirement of bar association is for accommodating around 1,500 to 11,000 2,000 members, which will be difficult to achieve given the size. গোটেই ৰিপৰ্টত কৈছে বাৰৰ লগত ডিছকাশ্যন হ'ব ন নিশ্চয় দেন
Because well, it will be a my lord, more steel composite structure, which can be dismantled.
These are more steel.
Yes, so it will take lesser time than my lord, having a my lord, composite structure.
Now, as on date, how much advocates are being given the means place out there in CGM?
It says my lord 1,500 to 2,000, last line of that particular page. My lord.
2,000 advocates are sitting out there.
Maybe the membership, my lord. It's not
The members are there. It's a different thing, but
They-
are they actually being allocated areas of 2,000? I don't think so.
I'll have to check my lord exact my lord numbers. I'll get it.
That's why he says, my lord, the requirement of the bar association is of 1,500 to 2,000.
Maybe
That's
some
a different
maybe
demand.
some
That
discussion.
bar association will consider when we go.
500 probably my lord, daily purpose, my lord, at least for this temporary.
How much is the footfall?
I'll get it my lord. Footfall.
Find out that.
Yes.
That is the
Yes.
important aspect.
Going by the data given here, 1,500 to 2,000, all these three are my lord, looking to be imaginary. Because it will not cater the needs. If we go by 1,500 and 2,000.
1,500 is too big.
Yes, my lord, that's true.
1,500, Here, what will be the square feet? 250 square meters per year would be 4 into 1,000 means it will be around 11,000 square feet.
Yes.
11,000 square feet would be how much? No, it's quite a sizable area.
No, sir.
11,000 square feet is quite a sizable.
Yes. One thousand square meter. 250 square meter per floor into 4. Square meter, 1 square feet, 1,000 square feet of.
And what has happened as regards to shifting?
Yes, sir.
Some of that.
Lordship will find it, my lord, in the chart, my lord. Subsequent to that, my lord, in the picture. Yes. Here is one status report of proposed GAD building at Pan Bazar to accommodate student.
Last page.
Last page of this chart there.
3-page chart is there, my lord.
Last one.
Landscape mode.
That starts, my lord, status of proposed GAD building.
So it will go pranam to the receiving.
So far as the my lord, Pranam Commission is concerned, my lord, they will be shifted to the curve house in the Dispur area. And my lord, regarding the my lord, police commissioner, my lord, that instruction that just now I placed, lordship will see the third page. Commissioner has been shifted in February 2025 itself, but my lord, a portion of the building is still occupied by a machine. Machine is lying there, my lord. It has been mentioned there. MSC server. Highly confidential service device. Now, my lord, the central government has been requested to dismantle it, my lord, and to shift it to any location. That we have requested in June itself, my lord. So for some technical reason, my lord, it's not been shifted till now. And it will be done, my lord. They are looking at it.
So in other words,
Things are moving, my lord. Only thing is
the government also has no urgency in completing that.
we have the urgency, my lord, but because of
No,
these
you
technical
cannot.
reasons.
You cannot do unless you take care of something.
Yes.
Because the main problem is
Well,
the three of the things which you have, the first one which we have given is not adequate.
no, there is only one.
The second is 2 years, the third is 1.5. Meaning thereby till 2 years or 1.5 years, that project cannot come to it. Because that portion is
Yes.
required.
It will be
disband.
occupied.
So that is one. Your commissionerate is in the hands of the central government and the central government there, DGCSR. DYSCL. Somehow you are the main person who is posting the phone. They have made a request to you for dismantling, you have to take steps against that. For that, so that things can move. We are also, Mr. Google, we also are interested in the fact that there should be an early completion of that river.
Yes, beautification.
It is not that we want to stall it,
Lots of.
but it cannot be allowed to the, when subject to, without the taking care of the advocates
Yes, I understand.
Why is it not possible that you take up some place somewhere
Yes,
nearby?
something there in the today's order, my lord, at least we can look at that model. Something, course of the, yes. But my lord, since my lord, there is a specific order on this particular point.
Because we are also concerned. If there is a delay of 2 years, it will amount to escalation of cost.
Lordship may,
At the end of the day, it is public money.
man,
Is also another aspect.
lordship,
At the end of saving 3.5,
man.
you may end up paying more than 4 times that.
In that even government can explore some possibility nearby, within the vicinity, some buildings.
Out there.
Lordship,
This is like in the BSNL quarters. and
Yes,
yes,
The BSNL area, which is nearby that.
lordship.
BSNL building is also there.
Yes, they have taken a rent in the BSNL building. Those are
Exactly. Some deliberation with the,
The statement you have demolished, we can compensate.
Yes, it's
Yes.
there in the, yes.
yes, shifted to the BSNL. Yes,
That part we can explore, my lord, provided some observation, my lord, at least I can, my lord.
because this process will not lead us to anywhere.
We cannot suggest.
You give us a proposal that please vacate this order, we want to continue, we are giving them this alternative. We'll make it.
Alternative.
You come
That
up.
definitely, my lord, will convey.
But these proposals, the main problem with these proposals is you are, the
Okay.
moment we accept one, your project gets stalled for 2 years.
Lordship. So lordship will just give us the liberty.
You are always in liberty. Who has asked you not
Fine,
to?
fine.
But not to throw them out.
No, that of
Feel
course,
alternative. Accommodation is-
yes,
Yes.
yes, fine.
You have an assessment,
Yes,
what is the footfall, daily footfall?
Yeah.
Then accordingly, you give a proposal that this is, we are proposing this kind of building is available. They will go there.
my
We will not say that they will, need to have a floor in the McDo program.
lordship.
Any suitable accommodation within that
Yeah.
vicinity.
Some way, something can be accommodated.
My lord.
And if necessary, you come up with that proposal, or find out and get a proposal for that. We can ask the DYSDI, check out the modalities, how it can be worked out, so that the things can move.
Lordship. Well, that can be,
Because
my lord,
that, if
explored.
that is done, it is much better.
Yes.
End of the day, you only pay
Ultimately,
rent.
again, 2 years we'll have to wait.
It
can
will be,
shifted
it will be
already.
confined, it will confine only to the rent. In monetary aspect also.
It is an immediate solution to the problem.
Exactly,
Yes,
exactly,
Rather than going for that.
exactly.
This will
Correct.
go for another
Yes,
24 months or 18 months. 18 months, they say,
exactly.
they issue notice inviting tender,
yes, again, it will.
which will take another long time.
2-3 months, it will go in that.
going
And
to
with
take
that,
us-
it is stalled. This is the problem.
Yes, correct. Absolutely correct.
So that is what. Now, as regards the shifting,
Lordship.
about you say that 100% of the first floor is complete,
Yes,
95 in the ground floor. Top floor 40%.
yes.
The reason is 40% is that some
Some is
area somebody is
occupied,
there.
yes.
One of the problem is because of that person, the central
Machine.
government is not taking any action on the basis of your
Disabling the machine.
request for dismantling that server,
Well,
because this is confidential.
yes,
And you take up a call on that and find out with the order. And as regards the Pranam Commission and all, if you are not,
my lord, yes, my lord, there, no, it will be shifted, my lord. That renovation and all, my lord, whatever is required is going on in Carbo. It will be shifted to Carbo.
so that is dependent on when Carbon.
No, it's already there. Carbo is there. It's there, my
That I
lord.
know, but the
State
Carbon,
GST
you
building.
want to have their offices there.
Yes. Because, my lord, that building is of the finance department and the Pranam Commission, my lord, it's under the finance. So that part they are looking at. Shift.
But how long will you take there?
That part, my lord, Yesterday I got the status, my lord, today is holiday, I could not get that, my lord. But lordship will give us some time, my lord, short time. At least that can be placed by what time it can be shipped.
Huh?
That I can place.
No, because at the end of the day, you cannot progress
Lordship,
unless you find out
Yes.
any place.
that
for
by
that.
accommodation. my lord.
But,
My lord.
and prior to that, the lawyers will be happy being accommodated in their own place. And we are,
That's
we can also,
Agency is yours.
agency is yours.
That, my lord, part we will explore, my lord, whether it can be accommodated some other place within this, my lord, vision.
Okay, now, that is, okay. Now, what about the toilets? Specific?
My lord,
That report
that
is there.
flag, in the report itself, first column, my lord, district wise is there. As to what steps are being taken insofar as maintenance of the toilets in the courts complexes and the funds received in these regards. The problems faced by the respective districts are at serial number 8, page 4. Chirang, Dorong, wherein Miller, the funds are not received. Serial number 8, my lord, Chirang, it says in the court complexes under Chirang district, the toilets are regularly cleaned and maintained by the engaged sweepers to ensure hygiene and usability. No specific funds are received exclusively for the maintenance of toilets. The expenditure as and when required is met from the general maintenance allocation of the establishment.
So you're not getting funds.
Yes, my lord. There are, my lord, several districts, my lord, Chirang, serial number 8, then 9 also,
Wrong.
10, then 11, then 12, my lord. In 12, my lord, funds are insufficient.
Yeah, Dhemaji, there's an outstanding.
Yes, my lord. Outstanding is also there, my lord, in 2-3 districts.
So some payments have been received in Dhubri
Yes,
and Dhubri, 5 lakhs have been received.
yes, an amount of 80,000 has been received by during the financial year 25-26 under the head wages. However, purchase of cleaning materials such as so and so, so and so, so and so has been made so and so. The all are made from office expense heads, my lord. So far as but one thing is there that in all the establishments, the persons are there for doing the cleaning, whether by outsourcing or by contractual or by contingent basis. The my lord, persons
So
were
there are problems as regards receipt of
fun,
funds.
fun, my lord.
And it is only in these 4 districts.
No, there are other, my lord. Dibrugarh, then my lord, Jorhat, serial number 18.
So Dibrugarh have got 13 lakh.
No, 13 lakhs, but there is another problem. The toilets of the establishment so and so and the establishment is manned by the fund of outsourcing of cleaning and sweeping. Then my lord will come Naharkotia, there is problem. Not sufficient. Outsourcing of cleaning sweeping service, which is not sufficient.
Naharpati, what is this subdivision business? They have not yet placed it before us. There's nothing has been done to the effect. Subdivisional quarter, the PWD makes an estimate of 90 crores.
Dibrugarh.
Subdivisional judicial court is 90 crores. You mean?
Yes, it says here, my lord.
Eh?
This is with regard to, my lord,
What is the cost of
building, court building and residential quarters.
Yes, what is the cost of the Sipsagar?
Sipsagar,
No, the much less.
yes,
I mean, now much less. It is not even a quarter of
yes.
this subdivision district. This is the estimate which is being placed by the PWD. That too on a flat land.
It has to be
Okay, don't
reviewed.
make a mini Taj
In
Mahal.
in the other,
43. Only three code. You need a Munsif. You need a SDGM. And at best, an additional district judge.
Lordship will review in the administrative side, my lord, this, perhaps.
No,
Exactly.
no, in an subdivisional code,
Yes,
you may have only three.
yes, I
It
understand.
can't be more than that.
Yes,
So you have therefore a Munsif. Then you have
SDGM.
what you call the SDGM.
SDGM.
And number three is additional district.
yes.
Yes, sir, but what is the total proposed courtroom in this building? Now,
Now 10 was.
10 proposal with 90 crores.
It is going to be the same like Bukakhat.
Yes,
Have you seen that building?
no, but I have
Ah.
heard, my lord.
I think it would be not less smaller than this court. This court. The judges' chambers are bigger than this courtroom.
This is non-application of mine, my lord.
There are only two courts. We've been asking the state to provide us one additional district judge. They have not provided that post.
Hmm.
But we are very happy to construct the building with 7 or 8.
Anyways, that's beside.
Then, my lord, Jorhat also there is problem regarding fund. Kabi Anglong, Kokrajhar, Majuli, Morigaon,
All problem.
problems, my lord.
So we then have to ask the funds have to be given by whom?
By the,
By the judicial department
yes,
in consultation with the finance.
yes.
But this has to be outsourced.
Look.
Cleaning has to be outsourced.
All are outs, whether some are outsourced, some are contingency.
It has to be cleaned up. Because the judgment of the Supreme Court makes
Yes.
it very clear. The maintenance has to be also a part of the project.
This is the most essential part, my lord.
Most-
Most essential. I have checked up a lot in all the establishments. There are persons.
You look into this report.
But that part of it.
এইটো দিছোতো এইটো প্ৰথম যোনটো আছে প্ৰথম কলমটো দিছ কলম এই গোটেই কলমটো আছিলে
Mal,
You have a look at it
Lordship,
and respond.
Mal.
Okay. And what is as regards the construction, the status?
Yes, ongoing construction status, my lord, I have given one short note, my lord. This is report regarding,
Last page.
sorry. It, yes, my lord. This is status report, my lord.
Last two pages left.
The one wherein your lordship has seen the GAD regarding the status of, yes, ongoing judicial infrastructure projects, my lord.
No, this is as regards ongoing judicial.
Ongoing,
But
ongoing.
we are concerned with toilets. What has happened? There are 35 or
35,
30
perhaps, my lord, he'll be able.
toilets to be-
But that matter is there in the report. Every district now it is.
35 for report. এইটো
Some has been completed, some work orders issued.
Look, this ongoing report is with regard to the judicial infrastructure.
No,
the
that
court,
we
yes,
understand.
yes.
Work is in.
Toilet is here.
Retender and the. Madam, have you looked into this status report?
I am only to bring forth my learned friend has provided your lordships, because I am not.
No, what Mr. Gogoi has given just.
It's not with the report, ma'am.
Sadly, your lordships, nothing is ever provided to me, so I cannot assist your lordships in a very proper manner. Uh, Is being.
Yes, Mr. Gogoi, serial number 17. This will also go west.
It has to be done.
17.
Till you file.
How money is being spent.
Lordship. Serial number
They are
17.
constructing those toilets and then it will be demolished.
Yes, ma'am.
Isn't it?
That one it will have to be, ma'am. Temporary also will have to do that.
That's correct. So therefore, some decisions which.
Yes.
we-
In fact, my lord,
taken.
a different location will be, my lord, more convenient if at all is available. That we will have to, my lord, work.
We will look into the other judicial infrastructures on the next day. And in the meantime, we today deal with, we passed an order fixing it on 2011. You give a copy, you have given a copy to him.
Yes.
He will respond to this. Number two, as regards the district which you are mentioning out here. There, we'll ask him to respond.
Yes.
What, as regards the problem, the fund.
Lord, my understanding is that so far as maintenance fund is concerned, Lord, there should not be any, Lord, slowing down of flow of funds with regard to maintenance, my Lord. The funds, my Lord, the fund, it's not like, suppose here there is a report that 3,50,000 is due to be paid to the contingent workers. They have paid 3,50,000, then they stop again, requirement arises. There's continuation of the fund, my Lord. So far as maintenance is concerned, my Lord. Otherwise, again, there will be backlog of salary and.
There is a problem whichever, however it happens, because these are appointed. These, although some are outsourced, some are appointed temporarily. For that, prior to the budget being prepared, is the requirement for submission of the proposal by your officers.
That I can ensure that the concerned district judge or CJM establishment, they will, my lord, so far as salary proposal are concerned, I'll request the registry also that they'll
They
submit
don't
the.
do one of that case.
Yes, ma'am. In fact, before 31st March, my lord, say in the coming financial year, before that, they may submit the proposal.
They
A lump sum
have to
amount.
submit those
It is-
proposals.
that is there in the budget.
On the basis of this, you see, these proposals which are there on outsourcing. These are portions and here that means there are other persons who are not within the employment of the district judiciary or even the high court. So these amounts do not come from the consolidated fund.
Yes,
These are based upon certain budget proposals.
correct,
And these budget proposals have to be brought within the budget
correct.
as per Article 202. Then only they can incorporate. And if you don't do it, then it will lead to prospective approval.
Yes,
One of the
Second,
cases which I
delay.
did it was of Mr. Chamaria,
Yes, ma'am.
where he had the finance department
understand.
has been gracious enough to give a post facto.
I
But
understand.
this was done after much later,
Yes.
in the month of October they have done.
Proposal to GS.
Have to estimate, the maintenance, cleaning, all these estimates has to be given prior to that.
It should be a separate. head,
Look, it's
for
nothing-
This particular head, for maintenance and cleaning, this much amount will be required. for
My
this particular-
instruction is that from my officer is that, my lord, there is never a delay in submitting proposal by the established. One instance, perhaps lordships has got one example in a case, but in most of the cases, they submit the proposal.
If it is a proposal is being submitted, they delay, then point it out to us.
Yes, my lord. But I'll ask the registry that,
That's appropriate orders. We observe, make it very clear
yes.
that there should be a head
Hmm.
on the basis
Yes.
of cleaning and maintenance. of the
Exactly, my lord.
toilets.
That is,
So therefore, when these heads are the proposals have to be submitted and the finance will have to also take care.
I'm highly obliged.
And it should be.
That-
part
that
of
will
the
do.
Annual budget, madam, that is before 31st, whatever is
Has to
submitted.
be
Then
submitted
thereafter,
prior
any
to that.
supplementary
So
required, there's a-
steps for-
exactly.
Whatever.
That will do, my lord. That
And
will
where
suffice.
there's been no steps have been taken, any post facto approval is required, point it out to us.
Yes, ma'am. Yes, that will do.
Point it out to us, so we'll ask you to respond to your reports. And in the meantime, you point it out where there is, you require post facto approval.
Yes.
And for this cleaning purpose, you have to give a budget, proposal,
Yes,
budget
correct,
proposal.
yes.
Then only they can handle
Yes.
this. So these two are, this is the only thing which I need to pass an order and you find out
Yes.
as to whether there is, you have submitted this, but this seems to be very, it will take, it will be time
That's why I
consuming.
just some observation so that I pursue the authorities to my lord. go
We
forward.
just observe that.
Only
it
that
will
any
take
other
some
option,
time.
my lord.
First,
Yes.
first proposal is, does not appear to be good.
Lordship.
As regards 2 and 3, it is time consuming. So if you can have alternative proposals,
My lord.
we may not say further,
My lord, I understand.
including rental.
Yes, if that,
That can be said, my lord. That can be said, my lord.
If that is done, it is the best.
wait,
And if it can be done in this BSNL thing,
Lordship.
and we'll pass a direction that the observation that the ARs will take it up as regards the dismantling of the server.
Lordship.
Yes, where we have the additional advocate general, yeah, Nagaland. Have you done anything on the aspect? Yes.
Yes.
Yes, Mr. Advocate General.
My lord, we have progressed a lot. Am I muted? My lord can hear me, my lord?
Yes, yes, loud and
Yes.
clear.
Please. So there has been a lot of progress as far as the furniture business is concerned. The file has been processed by the law department.
Okay.
And unfortunately, we are having a pen down strike in Nagaland for the past few days. There is a lot of agitation because of those who are not coming from the routine stream for being conferred IAS. There's a small percentage of people who are not really from the direct channel of officers who are entitled to the job. On that, there is some confusion as far as the agitating members are concerned. So there's a pen down strike, so we will just want that to be cleared out. Hopefully, it should be done in a short time. Then we'll identify exactly what furniture we want. Because I was told that these things were conceived at the initial stages, and that was for a higher budget. Now we have to adjust with the funds we have so that we can first identify exactly what we want, and that will also be processed. So I think we are going in the right direction without much delay. Maybe if this pen down strike was not there, I could have given a rough estimate. So we are on the right direction. And we are being pursued by all the learned judges on the finalization of the High Court. I had been recently to Guwahati for that meeting. So everyone was after me to know what happened. So we are going on the right track. I think it will be done fast.
So, When are you proposing to issue the tender or issue the work order for that?
I think as soon as this end of strike is over, we'll identify the fund. It will be done in this part of the year itself. Then it will be normal course. Things will take place. There won't be any delay on that. I
So
got
there's
the
no,
instruction morning.
Huh?
I got the clear instruction today morning from the law secretary on this. That it was not for the pen down strike. Because I'm also insisting on a date, just like how your lordship asked me. I also asked the same questions to them. Only then I can give a clear report. So this is what I was saying. I think we are going on the right track. There shouldn't be a problem. This part of the year, it should be. We'll do
So
it.
let us have it, we are having this matter again on 2011.
Okay, very
We get an update as to whether any work order have been issued.
good. We'll do that. Well,
And we expect with Mr. Advocate General's high office taking he's already proactive, but using his high office, he would obviously get it done.
it will run. And the government is keen on doing it.
Yes. So we'll fix it on that date on 2011,
Okay.
along with the other
Will do.
matters for giving us an
Very well.
update on that.
Very well. Will do. Problem.
We'll pass the order.
Please.
Lordship may incorporate, there are two data available in our report regarding Kachar and Dhemaji, that they have already submitted the requirements to the High Court, but the funds are not coming. If this
High Court for what?
For release of these funds for paying salaries,
Salary for?
the cleaning staff, my lord. So
Ah.
since we have these two data, Lordship can incorporate.
No, that's
there in the
fine.
direct-
Why they are making it to the High Court? They have to make it to not to the High Court. They have to make it to the judicial department.
Process is that they
No.
send the
The process is
Directly
to the
to the
judicial
Bharat.
department, and the judicial department takes it up with the finance. This is how it works. They don't do it at the High Court.
Well, I'll clarify it, my lord. I'll clarify it.
Because the last time when I got that order done, the proposal was directly submitted by the MACT to the judicial department, and the judicial department took it up with the finance, that the finance approved it, gave a post facto approval, and this is how it works.
But
What is the High Court going to do?
here, my lord, the
High Court has, I think, better business to do.
in the administrative
And where's
side,
your
this-
register administration?
this submit
not
the
here?
proposal to the High Court.
Supplementary list, item 1 for admission.
Yes, Mr. Imti, what has happened in this case? Have you filed your affidavit? Or affidavit has been filed?
Allow me to take some more time. Our personal capacity.
This filed by the register Guwahati High Court. What about the affidavit filed by the government?
Lordship, we have not yet.
Mr. Imti, we can't hear your voice.
We have not yet filed affidavit. Not yet filed. Lordship, audible?
There's some problem, I think. What happened to your? Okay, we do one thing. As no affidavit has been filed, we fix it on 2010 to 2011, 2025. In the meantime, you file your affidavit without fail this time. List this matter, it is seen that the affidavit has been filed on behalf of the respondent number 5. But the state government have not yet filed an affidavit. Mr. Imti Imsong, the learned additional advocate general, seeks for further opportunity to file the affidavit. It is duly taken notice of that the court have issued notice on 1/9/2025. First, a final opportunity is given to the state to bring on record the affidavit on or before 19th of November 2025. List the matter again on 2011/2025. Mr. MD Imson, this is the last date.
I have serial number 8, my lord. The item number 5. Item number 5, my lord. There are 3 writ petitions, 3 works. Item number 4 relates to serial number 9.
Serial number 9.
Item number 5 relates to serial number 8.
Serial number 8.
12. And item number 6 is item serial number 12, my lord. 12, my lord. I can use 12.
So these are the 3 contracts.
3 contracts.
Now let us see this clause of each subject. Qualification of the bidders.
Page 115, my lord.
All the bidders should furnish the following information and documents with its bid. Section 3, qualification information unless stated otherwise in the appendix to the ITB. Scan copy, scan copy, scan copy, scan copy. And so qualify. Scan of the original document regarding constitution and monetary experience certificate in works of similar nature and size for each of the last 5 years with certificate from concerned officer of equivalent experience certificate, scan certificate of evidence of availability and qualify for the award. Each bidder in the name should have the following: average, achieved, and so on. So 4.3.8. This is to qualify. For award of the contract, each bidder in its should have the following: achieve a minimum average annual financial turnover in all cases of civil engineering construction equal to the amount indicated in the NIT during the last 3 years ending 31st of March of the previous financial year, duly certified by Chartered Accounting. Satisfactorily completed at least one contract of highway of North as a prime contractor or as a partner of JV with similar work. B. This is for the purpose of qualifying. Each bidder must upload the scanned copy of the following along with the submission of the affidavit of such other certificates in demand. Submit the share shall be non-responsive. Each bidder must demonstrate, bidder who meet the minimum qualification criteria will be qualified only if their available bid capacity is more than the bid value. This is 4.5. Meet the above qualifying, they may be subject if make misleading or false. Now, this is only 4.3, 4.3.5. This is only for the purpose of ascertaining as to whether they have the experience or qualification.
Experience or qualification.
Now, is it your case that they don't have the experience or qualification?
They have, my lord. From their affidavit, my lord, they meet the bid capacity, my lord. But, my lord, I want to bring lordship to point 4.3 at page 116, 4.3 B.
4.3
B.
capital A.
Capital A, my lord, to qualify for award of the contract, age bidder in the name of should have the
B,
following.
satisfactorily completed at least one contract of highway as prime contractor or a partner of the JV so and so.
My lord,
Ending or via to the
4.3
one
capital B, my lord.
capital
Capital B, 4.3 capital B.
B. Each bidder must
Upload the scan copies of the following documents along with the submission of online bid. Number two, my lord. Number two, such other certificate as defined in section 3. My lord, page 132. Page 132 is the section 3, my lord.
Section 3 is where?
Page 132.
To be filled by the bidder in this section and for documents submitted in area will be used for the purpose of post qualification as provided for in clause A of the month. Yes.
Page 134, it is for the JV partner, my lord. So it is not applicable, my lord. Page 135.
Individual bidders, year of construction, legal status of the bidder, power of attorney, total value of so and so, refer to ITB 4.4, total value of the work for 2024-25, average.
Page 135, my lord. Information on bid capacity. Works for which bids have been submitted and accepted, and works which are yet to be completed, as on the date 7 days before the last date for bid submission, as per clause 135, my lord.
Information on bid capacity, works for which
Bids have been submitted
and accepted, and work which are yet to be completed as on
7 days
7 days.
before so and so.
7 days before the last date for submission.
Existing commitments and ongoing work, B. That my lord, 4.4. Page 117, my lord. They have to, as per this certificate, under section 3, they have to submit the works awarded to them before 7 days of last date of submission of the tender. In the uploaded documents, here it is recorded as nil. Kindly now turn to page 117, my lord. Page 117.
Huh?
117, my lord.
170.
117. That formula, my lord, are available to count the available bid capacity. B, component B. That is required as per 135.
Yeah.
Value escalation factor as specified in this section shall be used to bring the value to the level of current financial year of existing commitments and ongoing works to be completed during next 1 year.
Yeah.
Although they have the bid capacity, my lord, as per the provisions of this clause 4.3, they have to disclose this, my lord, because my 4.3 B2, they must, my lord, each bidder must upload the scan copies. So, my lord, in their scan copy, they have shown nil, my lord. They have shown that they don't have any existing commitment. But at page 40 of my writ petition, my lord, they have been awarded with an work which has been not shown as per this table, my lord. 135. And there is no provision. In fact, I have not found any provision in this RFP that the bidders are at liberty not to disclose any document due to oversight, my lord. As per their affidavit, the respondent number 4 Due to oversight, he failed to upload that work order at page 40, my lord. As per the RFP, there is no such provision, my lord. You have the bid capacity, my lord, but it amounts to misrepresentation, my lord. And my lord, one thing is there, my lord.
But Mr. Rekha, tell me, why is that particular document required?
As per the RFP, my lord,
The RFB is in the is in
To-
relation to qualification.
to count the component B, my lord.
Means,
Component
are you
B,
saying that component B cannot be counted? The available bid capacity cannot be counted unless you have an existing contract.
my lord.
If you don't have an existing contract,
Yes, my lord.
can component B be counted?
If they don't have any existing commitment, my lord, then my lord, as per this component B, that will not be counted.
Not counted.
But
That means, are you therefore submitting that a person who does not have an existing contract cannot participate?
they can, my lord.
Now, how?
My lord, if they meet the bid capacity, my lord, they
So
may.
therefore, they meet the bid capacity.
They meet, my lord.
Ah,
There's no
then?
doubt about that, my lord. But, my lord, it amounts to misrepresentation, my lord.
So you mean to say, if B is not being mentioned, because here there is a minus B,
Yes, my lord.
this amount A into N into
2.5 minus B.
and then it is subtracted by B.
B.
So without disclosing B, you cannot, and B pertains to value escalated factor as specified in this section shall be used to bring the value of the level of current financial year so and so of existing commitments and ongoing works to be completed during the next 1 year period of completion to which the bid. So you mean to say that if you have an existing commitment
Yes, ma'am.
and if you don't mention B,
Yes, ma'am.
then the available bid capacity cannot be arrived at.
My lord, in their case, my lord,
Can you make that formulation or submission that you see, kindly come to 117,
Yes.
available bid capacity. Available bid capacity is A into N into 2.5.
Five.
And
Minus
then it is subtracted by B.
B by existing.
Means the existing commitment which is there is being subtracted to arrive at the available bid capacity. Meaning it appears to me, subject to what he says, that exists that once you have taken the benefit of some of your existing bid capacity in respect to some other contract which is presently ongoing, then you are to subtract that so that for this you should have an additional bid capacity to carry out the work.
Yes, ma'am.
So therefore, without B being mentioned, you cannot arrive at the available bid capacity.
Yes, ma'am.
So therefore, your submission is, if you have an existing, because if you don't have an existing, B is not there,
Not
it's
there.
zero.
Zero.
But if you have a B,
Yes, my lord.
then you subtract it by B so that, or in other words, if we may understand, that a person may require 4 crores for the purpose of having a particular contract. So he uses these 4 crores in respect to a contract which he have already done, and on the basis thereof, he has already obtained the benefit in respect to an existing contract.
Yes, ma'am.
Now, as he has used that particular thing, so therefore, this existing contract has to be subtracted from
Original.
the multiplication factor of A into N into 2.5.
Yes, ma'am.
That appears to be
Yes, yes, ma'am.
what can be mentioned, because it means that you, or in other words, the reason why they have mentioned the existing contract is that you cannot take the benefit of some other contract if you have already taken the benefit of this contract or that earlier contract in respect to an existing contract. It
Yes.
appears to be that understanding.
Yes,
Is it your written case, stated case in your writ petition?
my lord,
My question is that,
yes, my lord.
is it your stated case in your writ petition? Because it appears to be, therefore you have a subtraction of B.
Paragraph 10, page 11. my lord.
Mandatory requirement of the year for which you demand 1 month. No, this is not your case. Mister, I don't think this is your case.
My lord, the respondent number 4 has the bid capacity, my lord. My case is this. my lord.
No. It is not the case of respondent number 4. How will you arrive at a bid capacity? You are saying that he has the bid capacity, but what is the basis of his bid capacity unless you say about B?
They have calculated this, my lord, in the affidavit.
We'll consider their calculation later on. But tell me, how do you calculate and arrive at the available bid capacity without subtracting B?
As per this, my lord,
A is what?
maximum value of civil engineering works
Works executed in any year
in the last 3 years.
Escalation factor means if you are doing it for the purpose of in 2021-22, it will be escalated. The amount will be escalated by multiplying it with 1.61.
1.61.
Engineering to the level of the current financial year 2025-26, taking into account the completed as well as works in progress. Okay. Number of years prescribed for completion of the work for which the bid is invited. This is N.
And B.
Number of years prescribed. So this amount into means in the instant case, if we consider the case of that serial number 9, the period is 12 months. So it will be 1 year. For this maximum value you are arriving at A, you have to multiply into 1. Then you multiply by 2.5 and subtract it by B. Value escalation factor as prescribed in this section shall be used to be clear, meaning thereby if that particular contract which you are mentioning, he did not disclose. That particular contract into
2.5.
no, not into 2.5. If it is the present contract, then it has to be multiplied by what? The contract which you are mentioning that it is there in your notice in your writ petition.
Page 40.
Page
40.
40. So it is some 46,49,000. This is year of 2025. So you multiply it by 1. So this amount you have to minus.
This amount 46, my lord.
This
46, 49.
you- Or you have to subtract the amount you have obtained and then observe as to whether you have the available people.
Yes,
So without mentioning B, an existing contract, there cannot be a formulation arrived at as regards the available bid capacity. That should be your submission. What do you say, Mr. Gugoi?
Well, page 92, my lord.
Yes, my lord, to determine or ascertain this particular, my lord, 4.4 clause, my lord, one will have to disclose it. Who is the respondent number 4? It appears so, as not disclosed. But my lord, after his disclosure, when we verified it, we have found that, my lord, despite, my lord, this subtracting this particular commitment of 2025, which he already has, he has a bid capacity of 4 crores. Whereas the work where he has participated now, which is the subject matter of the present bid petition, there, my lord, is only 2.17 crores. So we held that, my lord, he has the
So
capacity.
therefore, what you
Otherwise-
did, you asked him.
We, moment, my lord, the petitioner submitted an objection to that, my lord. We submitted a letter to the petitioner, respondent 4 to explain on this point. Then he apologized that inadvertently he, my lord, that particular figure, 49 lakhs or something, whatever is there. He, my lord, has not mentioned it in this particular chart, which is at page, lordship will find. it.
What do you do,
But
how
that
do you
will
take-
not.
but how
affect-
did you take care of 4.3B?
That I will explain.
Which says
Yes.
failure to submit the certificate document as specified above shall be make the bid.
Yes,
non-
my lord, that's the point. Here, my lord, it says, my lord, failure to submit the certificates or documents. This, my lord, particular form ordered, my lord, in the appendix, page 135, lordship may kindly see. He was supposed to disclose it in this particular format, page 135. He has submitted this document. It's not that failure on his part to submit this. He has submitted it as nil. So here the issue is, my lord, what the petitioner want to project, that lordship will find that page, my lord, 117. 4.5, lordship will have to see 4.5.
Yes, I will look into it.
It says, my lord, even though bidders meet the above qualifying criteria, they are subject to be disqualified if they have made misleading or false representation in forms, statements, affidavits, and attachments submitted in proof. Here, my lord, otherwise, if we look into the present issue, it appears that, my lord, yes, there was false representation on the part of the respondent 4. But what is false representation has been described in the present, or it has been explained in this particular tender. Lordship will see that part. Then, lordship, that issue will come, well, whether he has actually committed or not, whether we have committed any wrong. Page 127, lordship will see 34.3. Clause 34 speaks about corrupt and fraudulent practice. Now, 34.3 says, for the purpose of this chapter, clause 34, the following terms shall have the meaning hereinafter respectively assigned to them. So that what is the meaning that has been explained? Possibility page 128B, subclause B. Fraudulent practice means a misleading representation or omission of acts or suppression of facts or disclosure of incomplete facts in order to influence the bidding process. Had it been a case that, my lord, the respondent 4, by hiding, my lord, this particular, not disclosing this, my lord, present commitment, he has tried to, my lord, mislead the tendering authorities, because had he disclosed it, his bid capacity would have gone down. But in the present case, his bid capacity is already 4 crores, where the work that, my lord, present tender is only, my lord, 2 crores 70 lakhs. So that, my lord, influence the bidding process, that part won't come, my lord. That's my submission. Supposingly, my lord, if he discloses it on a mala fide motive, my lord, he has not disclosed it, because if he discloses it, his bid capacity goes down, that he will not be able to participate in the particular tender. Same, my lord, his bid capacity otherwise, as a, my lord, contractor, his bid capacity financial strength, my lord, there is 4 crores. He is already executing, say, my lord, 1.5 crores. He is presently, his commitment is there. He is executing a particular work. That he faced.
But Mr. Gugoi, tell me one thing, were you not first,
Yes,
unless he did not object,
my lord.
were you not taken up? Didn't he mislead you earlier by not informing that 46 lakhs has to be deducted? I'm asking you.
Yes, that's why, my lord. We sought an explanation from.
No, you sought for an explanation when he intimated.
Yes, that's the fact.
So therefore, at
Yes.
first, he did not mention.
He has not mentioned. That's the fact.
It is a fact that he did not mention,
But
which he should have mentioned.
otherwise, yes.
Because that is how you compute.
Yes.
So therefore, how can you excuse him?
That's the reason, my lord.
Means
they-
if you
yes.
excuse him this case, in all cases he will do?
No, my lord, there is a issue, my lord. That's why I said, my lord. Supposingly, my lord, he has tried to mislead us with a malified intention. His bid capacity is said to 2 crores now, by excluding all the commitments. By if my lord said 2 crores, my lord. Now the project is, my lord, 2.17, 2 crores 17 lakhs. Now, if he discloses, my lord, whatever existing commitments are there, then it will come up that, my lord, his bid capacity is only 2 crores. Whereas the existing work, my lord, that we have tendered is, my lord, 2 crores 17 lakhs. He will not be eligible. To hide that, apparently deliberately, if he has, my lord, committed the misrepresentation, in that case, my lord, it has been defined that, my lord, it will be held to be a corrupt practice. But, my lord, others also he has the bid capacity, even if he discloses. He has the bid capacity of 4 crores, excluding all the commitments. He can today execute a work to the extent of 4 crores.
And the respondent happens to be the same respondent in all the three cases.
All the three matters.
If this be the so, then
My lord,
isn't he getting some benefit? Because he's using the same bid capacity for all.
no, my lord,
You are saying about 2.7 crores is one contract and he has 4 crores.
she was right. Then we'll have to see the chart again, my lord. What is the, my lord, yes, bid capacity, total worth of this, my lord, other 3 works,
Ah.
other 2 works.
Yes.
It is, my lord, 2.17 in, my lord, item number 4.
Because one is item number 8, serial number
Serial
8
item
is
5,
359
359.
and the second is 2.17
Lordship is right on that.
and third is 1.37. So if this, he is taking the same bid value for everything and not disclosing it, wouldn't that impact?
For 3 works, my lord.
Because he's asking for, he's submitting the same document.
Oh, my lord, I'm sorry, it's 41 crores. 41 crores. As on date, his bid capacity is 41 crores. Respondent 4's bid capacity is 41 crores. Even after excluding his present commitments.
And how many existing bids are there?
No.
Existing work. He's not doing any existing work. Now, are you saying that last 3 years he has no existing work? There's no existing work for the last 3 years. All works have been completed.
That's what he has said now. my lord. And the other side also, my lord,
And
there been some-
Mr. Another thing here.
3, 4, 5.
And these works have to be done with whom?
But here it will be, my lord, NH, PWD NH.
No, for the purpose of getting the benefit of bid,
My lord.
what are the works with which organization?
It can be any work, my lord. Where
With
he-
which organization?
my lord, that existing commitment and all. It may be anything, my lord. Where he has got a financial liability, my lord, for executing a work. It may be a central government under central government or a private.
Therefore, is it the case that he has no contract, existing contract for the last existing contract as on date?
That is what he has submitted now, my lord. In fact, had
No,
it been
how
there,
do you
my lord,
know? How do you know?
In
He may
that
be
case, my lord-
hiding that. They have only found out one. This is a serious infraction which they have done. Because you cannot arrive at the available bid capacity without B.
Yes.
And the B has not been disclosed.
No, might be, my lord, in some case, not in the present case, might be, my lord, there may be nil. Some cases there may be nil. So it will have to be arrived at.
No, if it is nil, it is nil. There's no knowledge. But you have been made to, at the time when you ascertain the technical bid,
Yes.
you were made to understand it is nil.
That part, my lord, yes, that's why we said, my lord, when, my lord, this was pointed out by the petitioner, we sought an explanation. He apologized and he has stated that I have got a bid capacity, otherwise also excluding this, of 41 crores as on date. So he can execute these three. My lord, he is the L1 bidder, we are getting at a lower cost, my lord. That's why, my lord, we have proceeded. Had it been a case that, my lord, if it is disclosed now and his bid capacity goes down, of course, we would not have accepted it. That risk we won't take, my lord, apparently. And why I'm saying is, my lord, Lordship will see, my lord, directory conditions and mandatory conditions, my lord. Lordship will see, we can do that. Page, my lord, for a moment, page 135, just, well, for a moment. Part of the appendix. This is the, my lord, 1.4b regarding the disclosure, my lord, for bid capacity. Then Lordship will see, my lord, page 1.5. Huh? Next, 136.
136.
Yeah. Clause 1.5. Yeah. Lordship will see, my lord, it's the availability of key equipment essential for carrying out the works. Lordship will see the note and the last line of the note, my lord. Any conditional evidence of deployment of the above equipment or inadequate proof as required for any of the equipment shall make the bid non-responsive. It has been mentioned that if you don't disclose it properly in this particular chart, it will be non-responsive. Same is the case in 1.6. So where it is required mandatorily, we have mentioned it.
You have also mentioned in 4.3.
Yes.
4.3, you have mentioned if you draw this implementation.
No. 4.3, we have stated that if you don't upload it.
No, failure to submit the certificate document as specified above shall make the bid non-responsive. You have mentioned that.
No, document he has uploaded as nil.
No, he did not upload the certificate of B. That is the case. He did not fill up, he did not upload, and it is his self-admission that,
Yes, that
we
much
have
is evident.
forgotten. Then how was that your entire assessment is wrong?
But no denial to the effect. Because it's record is very clear, madam. Only after the, my lord, issue was raised by the petitioner, yes, we have.
And you have rejected it on as if it doesn't seem to be proper. Maybe an L1 you go for a fresh tender, it's a different thing. But the question doesn't arise that if this is done, because this is in very absolutely the moment you are, yes, you have the right, you being the author of the document, you can very well do whatever you feel like. But the fact that he has misled you is not in doubt. And you cannot compute the available bid capacity without the information. So the entire exercise carried out by you without taking into account his B has rendered the entire exercise bad and making him qualified. So that qualification has to be held to be bad. You go ahead with a fresh tender in respect to these three. That's the only way out.
Lordship. So, my lord, this is my humble submission.
Understood. I have understood. You have got a lesser. But you see, if you allow, if I have to allow, it means I have to give you, say that, okay, you are okay with this. This will have a strong effect later on. In every case, it will be there. And it will lead to, I'll say, this will lead later on into a big problem because at the first instance, when you made the technical evaluation, you did not know him unless and until he had pointed out.
Yes.
Yes, what do you have to say?
It's an admitted fact that that 46 lakhs worth was not disclosed. What we had is the form was submitted. Not that the form was submitted, but it was stated as nil. That is an admitted position. But now this 46 lakh worth, when subsequently a clarification was sought from us, we had admitted that yes, this work was allotted to us, but due to an inadvertent error overlooked that we had submitted that bid.
But Mr. Counsel, tell me, how do you arrive at the available bid capacity? Minus B.
First, since I had stated my existing works as nil, in all probability it was taken as 0.
Mr. Counsel, it is not known how many else other bids also there. They may not have found out. This is a very serious infraction which you have done. Then it is a case of misleading. I would not observe those words, but it is on the face of it, it appears to be a corrupt practice. And the moment I observe that your integrity pack goes, you will be blacklisted. But this on the, you see, the very exercise being carried out by them without knowing that there was a B, an amount which can be quantified in the aspect of B. makes the entire contract, makes the entire evaluation.
Lordship from.
And thereupon, the next course of action is that they have to ask for a fresh lender. Delaying it does not make any sense.
Lordship from the affidavit was
I'm not asking that it is to be given, Mr. Gogoi. I'm not asking that you have to give it to the next L2. No. Let's set aside this because the entire evaluation is wrong. So you have to go for a fresh evaluation. So fresh evaluation has to be done fresh. You take action against him for not disclosing, that is your lookout.
As per 16.5, my lord, his bid security may be forfeited, my lord. As per 16.5 clause. For misrepresentation, his bid security may be
That has been-
forfeited, my lord.
Yeah. Don't fight so much.
That is
I
the prerogative
this
of the.
much is okay. When it goes to the division bench, you say that. And the division bench order may. Okay, that's. Because because the ascertaining of available bid capacity without B is wrong.
But from the affidavit, they had taken that P as 0, because I had stated it as nil. So therefore it was taken as 0, the factor P. Now, only subsequently, this 46 lakhs is also taken into account. This 46 lakhs word, which is by the petitioner has mentioned, that is also taken into account. I have a bid capacity around 10 times. Understand, Lordship?
No, Mr. Counsel, there are many contracts which we find. Just for example, that they are jail contract. The jail contract, pursuant to certain intervention made by this court, it was made at 5 crores for MSME. This person concerned did not submit that MSME to get the benefit, although he's an MSME. Okay, to get the benefit. Now, can it be allowed? No. You have lost the chance. These are contracts where you have to be, you are asking for doing big contracts out there, you have to be more careful. And you knew it. And I would have understood that it was hidden out there, so you must have forgotten. You got it just around the 2 weeks back. Participate in a fresh tender, better off. Where is that evaluation, Mr. Counsel?
Page 72 of the affidavit.
Page
72,
of the affidavit.
yes.
No, evaluation made by the technical board. You
Yes,
saw-
that is part of the repetition. my lord.
Where is that?
Page 35 and 36 is the 11, 35 and 36.
We will,
36.
the record, my lord, the minutes is there, my lord, of the technique.
Show me the minutes. Why is it so low, Mr.? They have quoted so low, all the tenderers, or is it that it is an inflated bid?
Well, the out passes that series lordship has taken up. Central government has said that whatever be the issue, you just have an explanation. If you can explain by taking additional bid security, it should be allowed. And if he fails, that security will go and penal action will be taken. Because otherwise, PWD has that minus 10, plus 10 flat by. For highest bid, it cannot.
This is by central government.
It's funded by central government.
Okay.
Minus
Then
41
also it is very low. I mean,
Minus-
compared to it, one is 42%, one is 41%. 41% below means it's half.
Additional preference CVT. Additional preference. Given information.
Wait, yeah, that evaluation is there. Table of evaluation of the substantive responsive of the, yeah, that is there. Here you see total monetary value of the construction, Rana construction, 74.58. Padmavati, 40.92. Horizon, 57.
Company statement.
And the difference between him and him is very minute. As regards how much amount, as you are saying about the lower bid, his and his is just very fraction. He has quoted some 120 something and he has quoted just,
127.
you quoted 127.
Yes, my lord. Mine is minus 41.41 and him is minus 42.
That is what is very less. It is not that thing.
Lordship will leave it without notice to take a call. Whether allowed it or not. That Lordship will leave it without notice to take a call.
That I can, but his bid has to be rejected.
That leave it to Lordship.
I won't say anything further.
But my lord, there are three minutes of the three my lord different packages. Dates are same.
His average is 10 crores, not 41.
No, my lord, this particular, whatever is there is my lord prior to disclosure.
Understood, it is 10 crores, not 41 crores, what he is.
No.
Isn't there Abdul Rakib? Abdul Rakib, average annual turnover defined as billing for progress in work and completed in all classes of civil engineering is, it is required is 217.29. As per 4.2.8 small a. Rana construction is 36,677. Abdul Rakib is 1089.
Because my lord, it is multiplied by annual, my lord. This, as per the formula, it is this figure that we have arrived. This is the annual turnover.
Bid capacity. Bid capacity is 0, minus 0. And it has been found as
Because nil, my
41.
lord. Yes, the nil.
And his bid capacity has been found at Rana construction bid capacity has been found at 178 crore. Makes no sense. And he's the lowest amongst the four.
Yes, otherwise it's the lowest.
Lowest, no, the lowest of amongst all.
No, my lord, so far as the figure is face panel 4120.05 lakhs. If you go by the formula, bid
It's a
capacity
big capacity.
or turnover, my
Oh,
lord, turnover.
the big capacity.
Lord, sir,
Rana Construction is 178 crore.
my lord.
Padmavati is 62 crores. New Horizon is 140 crore.
My lord.
And Rekib is 41.
41 crores. Otherwise, my lord, going.
That is why I'm saying.
Compared
he's
to
the
the
least
other.
for everything. Very, very. And you have rejected Padmavati on the ground. The bidder had not submitted any similar nature work under similar nature category. And you have not done for him. This gives an additional reason. And if you have disclosed it, if you have not, had you know about that, well, at that point of time, you would have rejected the same. Because you have rejected Padmavati on this ground.
Or not.
Otherwise, he had everything. He had not submitted any similar nature work under similar. So you, if you have rejected him, you have to reject him. Hello, give me the other one also.
Yes.
Sir, can we have it on Tuesday? I'll dictate it in the.
I am retaining the on record.
I don't keep it. And these are not fit case for C. Will allow you to keep.
My,
But next time, the entire document.
yes, my lord, yes, my lord. Again.
Matter having been heard at length and the records having been perused, this matter on (28) 10/2025 at 10:30 AM at the first item for final disposal. In name order past earlier, you could be.
My lord,
Produce the records which have been perused is returned, you reproduce on the text.
well, on 28, my lord, kindly excuse my presence, my lord. I'll have some
No,
personal difficulty.
somebody else.
Somebody else will be here. I'm deeply obliged, lord.
Into only this aspect,
I'm deeply obliged.
because most particularly if Padmavati is rejected,
Yes, my lord.
then he cannot have an excuse. And had he known that, he has not. But then also rejected. After getting a clear way, everything done, and then you come to know, yes, then you are adding it out there. That means you are also violating the right of Padmavati.
Deeply obliged.
I'll take up Mr. Das matter.
Item 16, 17.
Your application is for review, na?
Yes, my lord.
For extension
For extension of
review
the,
Per se, it would be a, why do you, the period I have to enhance. Taking into account that the counsel who was appearing on behalf of the petition then did not inform you till 23/4/2025.
my lord.
That's the reason.
That's the reason, my lord.
I heard Mr.
T. Marngar.
The learned counsel appearing on behalf of the petitioner. The. You are paying for whom?
One, my lord. Any teaching.
NC does, it's assisted by Mr. A does, appears on behalf of the response number one. The entity here appears for the response number two. This is an application file seeking an extension. Seeking extension of time.
For filing a review petition, madam.
For filing of a review application as per the leave granted by this court. By the judgment and order dated 25/3/2025 in CRP number 92 of 2023, along with others set of revision petitions. The learning council is querying on behalf of the applicant submitted that though this court passed the order on 25/3/2025. But the copy of the order was only intimated to the petitioner on 23/4/2025. As would appear from a perusal of the forwarding letter issued by the council who earlier represented the petitioner. So taking into account the above, it is of the opinion that the petitioner herein should be entitled. He is required to be granted some additional time. Accordingly, this court permits the petitioner to file the review application on or before 24th of November 2025. It is further observed. You can file it.
Yes, my lord. Actually, the
It is also
review is
observed
ready.
that the revision so permitted, the review so permitted is in consonance with the judgment of the Supreme Court in the case of, what is that judgment? ANZ Greenledge. Otherwise, review is not permitted. Greenledge or judgment 1981. Supreme Court
There are two IAS, my lord, item 16 and 16 both.
Same order.
My lord, highly obliged, my lord.
Earlier round of litigation, you appeared on behalf of the Power Grid Corporation as well as the NETC also, my lord.
Okay, they let them.
No, ma'am.
My lord.
ANZ Greenledge versus Swedco, reported in 81. What are these? Oh, this matter.
Demolition law.
Any other date? At this stage.
Automatic officers when they are not site lots, when they found this as it is not.
Were you?
I am for petitioner in person.
Petitioner number?
In item number 15, the petitioner person is there. He is most
You are
probably.
Sanjay Sharma.
I am on behalf of Sanjay Sharma side.
Then you cannot be on the behalf of Sanjay Sharma. Are you a petitioner? Are you a petitioner?
Actually, not.
Then, are you a lawyer?
Yes, sir.
Where is your dress?
No, sir, I am not acting as a lawyer, sir.
Okay, what are you doing then? You have just come to witness.
Actually, I am the chief complainant in this case, but.
You are not Sanjay Sharma?
Definitely, I left the signature in this case.
Okay, so you have no business. Yes, what do you think?
Although I have not, they have not furnished any written lordship, anything in writing. They found it is as it is lordship, as it was on the last day lordship. I mean, some portion of the fourth floor has been demolished, not the terrace, I mean, not the roof. And third portion is intact, Lordship.
Third floor is intact.
I think he's a resident.
Yes, sir. So can I say one submission, sir?
You have no business. Where is Sanjay Sharma?
So he's now, sir, out of station. He requests me to appear.
He cannot appear. You are not a party here.
Yes.
Neither you are a lawyer. So you cannot appear here. I'll help you. When should I fix it? We dismiss it with cost. And you demolish it. That order I'm passing, you'll demolish it and put the bill upon them. It is which is permissible under 337.
It is already there in the order.
It's already there. So you do it, and if they don't do, then recovery as areas of land revenue as per Bakizai proceedings. This is the way out. Sell his properties. Or do you want their bank accounts? Details of bank accounts, should we attach it?
Only issue may be Lordship. Probably, I mean, the builder has sold those properties, third floor and fourth floor to somebody else.
Understood.
And they are not before your Lordship.
So what? Unhelp it. If they don't appear before the court, they know what is there, they'll let them file a writ petition.
Yes.
Isn't it?
Yes.
You have your lawyer last time, na?
Yes, sir.
Who appeared?
He talks at them, sir, I appear.
Okay, list this matter. When should I fix it?
Next week.
28th, I've got these three matters to dispose it of. And then 30? 30?
Lordship.
List this matter on 30, 11/2025. Oh no. Yeah, 11/2010, 2025. I go to 27/10 asil na? Oh, 28/10. Oh, into 30/11/10, 2025. At 2 p.m.
Lordship.
How far they here?